partner in the IPE. Chartered Accountant Praveen Bansalji is also here with me. So the two of us are going to take you through the today's session, which is essentially two topics scheduled from 1 o'clock to 5 o'clock. One is the compliances under CIRP. And then the second part of the session is going to be on management of a CD as a going concern under CIRP. So when the corporate debtor is a going concern, so what all things need to be done. So the first part of the session, which is on the compliances under CIRP. For that, I have with me my colleague and my fellow founding partner in TruePro Insolvency Services, Praveen Bansalji. Praveen Bansalji is an accomplished chartered accountant, and he is an accomplished IP as well with more than 30 years of experience. And under his belt are some very prominent cases under IBC, two of them being, very big Lanco Thermal and Lanco Solar, companies that he had been the RP of and successfully gone ahead with doing their resolution plans. So, Praveenji, shall I invite you? I think you are already there logged in. So why don't you just come on board and start off with the presentation on the CIRP compliances. And for the second part, then I will join you to take the second part, which is the management of the CD as a going concern. Praveenji, can you hear me? You should unmute yourself, Praveenji. I think. One second.
Yeah, I'm coming now. I think you can hear me now.
Yeah.
So we'll just start the process. The first part of it. I'll start with that.
Yeah, you can project the presentation and you can start.
Yeah. I'll just go through. This is the first side of it. I think it's on slide master. Just putting it up. No, just hold on. Yeah, I think it is visible.
Yes, sir.
Yeah, you can make it full screen.
Yeah, it's visible now.
You can make it full screen.
Slide should I?
You can click on the slideshow or the full screen.
Yes, slideshow. Now it is okay.
Yeah.
Now it is okay, right?
Correct.
Yeah. My topic is compliances under CRP. That's the first thing. Which is my favorite topic was CRP. My forte is CRP part of it. I think first slide which I'm going to put it on is the legal provisions. What are the legal provisions are there? Which I will just go through quickly. I have tabulated it under the table divided into different regulations. First is the CRP regulations, where the process timelines are there under section 40, under regulation 40A, which we have to follow. That means whenever we are conducting the CRP, the CRP itself is around 180 days process. And within 180 days, we are expected that we will be completing the whole of the process. And for every stage, there is a prescribed timeline. So we'll go through that a little bit more in detail, and I'll explain to you what are the common challenges you face it basically. And so that we are clear about it, how to manage the process timelines. And there are common issues there are a lot of common there are a lot of issues are there which you will face while you are completing when you are trying to complete the assignment within the prescribed process time. The second thing which the prominent part is the filing of the forms with IBBI. Of course, there are forms are there prescribed in regulation 40B. CRP 1 to CRP 8. I think everybody remembers well. Whoever has got an assignment, everybody remembers by CRP 1 to 8, which we have to follow regularly. And these these CRP forms are basically linked with the time, linked with the stage with which the CRP at which the CRP process is there, and is linked with the events also. So basically we have to understand that when the filing of the form gets triggered, and if the filing of form is not filed in a timely manner, there are penalties are there which come into play. So of course we should try our best that to file the forms with whatsoever information is there, and then we should move ahead, right? Uh, the next compliance within CIRP is the compliance certificate, Form H. Once the resolution happens, then we have to file the compliance certificate. I'm not going into, I will not go into too many details of this, because there's a Form H standard form is there where we have to provide all the information regarding the CIRP process. And of course it contains what the distribution is there and other things are there. Okay. Another prominent thing which we have to understand regarding the regulatory fees, which is provided in regulation 31A, along with the 3 regulation under IP regulations. These fees are basically payable by the IP, IPE, and is payable by the IP on his fees, and IP on the fees which is payable to the other professionals. Then there is a regular disclosure we have to continue to make it. The relationship disclosure is there, fees disclosure is there, cost disclosure is there. So earlier it was by way of circular, but now it is a part of the regulations. Regulation 8, Regulation 25, and Regulation 27. So Regulation 27 is regarding cost disclosure, 25 is regarding fees disclosure, 8 is regarding the relationship disclosure. We will discuss a little bit in more detail, and on the disclosures. And these disclosures has to be filed with IPA. Then of course there are other reports are there which you have to file it, the public announcement, monthly reports, and half yearly reports. These are again we have to file with the IP so that they understand what is the progress of it. So this is a basically broadly you'll be able to have a view about it, that what are the relevant provisions under which the compliance has to be made, what are the relevant forms are there which has to be filed, and so it will give you more clarity on the subject. Okay, can I move ahead now? The first I'm going to talk about the process timeline, IRP period. Regulation 40A. I have just copied the whatsoever the process timelines are there, so that we can just simply go on discussing. My advice to the IP is that you should make it a table whenever you get an assignment, so that you can understand what is the timeline which we have to follow, and what is the next activity we have to do it, so that we have got a full clarity on. We do not miss the deadline. So this you should keep in front of you always. Whenever you see that there is an assignment which is required to be executed. Now the first timeline, description of the activity, I'll just go through quickly. Commencement of CRP and appointment of RP is the T. Now the first challenge which comes into this regulation, section 16.1, is the NCLT order. Generally, it is seen that it is pronounced on X date. It is uploaded on the NCLT website on X plus Y date. So that means there is a delay is there in uploading the order, number one. Or there is going to be there is a delay. So basically the question comes in, how to handle this delay. because sometimes it has happened in one of my matter. It has happened that the name in the order was my name was not there. Somebody else IRP name was there. So we had to go for the correction. It has taken more than 30 days time. So many times it has happened that there is a delay on uploading the order. So these challenges are there. The question comes in that how to then comply with the requirements. So okay, my way of looking at it, if there is an extraordinary delay there, maybe around say week to 10 days time, then we should immediately submit the application for exclusion of it, because otherwise you will not be able to cover it, and you will be ending up with the delay and delay and delay. Okay. Then comes the public announcement. When the public announcement has to be done within T plus 3 days, that means within 3 days we have to do it. That means as soon as it is advised that as soon as you get to know that you are being the order is going to be pronounced, you should immediately prepare the draft application, draft form A, right, and send it to the ad agency, basically, who can give you the quote, and based on so that you can finalize it. Remember one thing: the public announcement has to be linked with the locations also. So generally, the size of the public announcement is more or less standard. So, but the IP need to discover which locations they have to cover. Basically, of course, registered office is there, and certain business location has to be covered. So basically, you have to do your research, find it out where the public announcement has to be made. 3 days is little difficult deadline, because you have to keep in the mind that that means if you say expecting if you're planning for it on third day, if by the third day, if you wish you want to get it published, then you have to give the final go ahead on the one day before that. So keep that into the mind. So that means public announcement has to be made within T plus 3 days. Uh, then then the submission of claims. The submission of claims is has to be there 14 days from the appointment of IRP. The question always comes in that if there is a delay in getting the order, how it will be covered. Generally, the practice which is being followed is that where in the form A itself, it is written that this is a date on which the order has been received. Say it is received in 2 days delay, and then that means the 14 days is generally counted from the date the order has been received. So this is the way the 14 days from the appointment of IRP is being counted. So this is the practically it is happening. What I am explaining to you. That means you will once you have announced the date, accordingly you will receive the claims. Okay, the claims are allowed to be received up to 90 days of the commencement. There is a regulation is there, regulation 12.2, which provides that the creditors can submit the claim within 90 days time. The question always comes in that what you should do of the claim after 90 days time. Two practices are being followed. Generally, there are certain IPs which are very clear, saying it that the IP doesn't have the power to accept the claim after 90 days, so they simply reject it. And if they want to get it included, they have to go to NCT and get the order. There are certain IPs are there who try to accommodate as much as possible. But definitely that has got its own problem in terms of the IM, because in the IM we have to state that how much claim we had to receive, we have received. So that means you have to continuously go on updating the basically you have to continuously go on updating the IM basically. So that is the challenge you face it. So I hope you're clear about it. Submission of the claims, 90 days timeline, and the challenge which you are going to face it. Then comes, of course, the verification is there. Within 7 days, we have to complete it. That means we reach to a T plus 21 days. So the T, let me repeat, T is the date on which we receive the, on which we basically order is pronounced. The day the order is pronounced, that is the date you will find on the order basically. Public announcement, we have to make it T plus 3 days. Submission of the claim, we get it in T plus 14. The verification of the claim, we have to do it then T plus 21. Within 7 days, we have to do it. So the verification, of course, the process has to be followed in terms of finding it out whether KYC is there or whether the complete form is there, right form is there, and the proof of the claim is attached with that. So these are the few things are there which one need to keep in the mind, and it has to be completed in T plus 21 days.
Can I just ask a question here, please?
Sure.
This T that you're saying, now supposing the order is received after 3 days, so when order is uploaded on the third day from the date of pronouncement, so what exactly is T over here? The
See,
date of
the
upload of the order?
T will remain date of the order. That is why I clarified that. See, ultimately, everything judiciary is going to follow the date on which the order has been pronounced, and the date of the pronouncement is written on the date of the order.
So essentially, how do you get over this problem when you see you have an order which is uploaded after 7 days?
See, that is why I said it, that if it is 2 or 3 days time, you can get over by delaying that, delaying the final date for submission of the claims. But
Okay.
if it is 7 to 8 days, then generally you cannot take it. You will end up delaying the process. So that means you don't have any other option but to go back to the NCLT saying it that please give me the exclusion for so many days, so that you do not miss on the process timeline.
Deadlines. Yeah. Okay. Thank you. Thank you.
Okay. A verification of the claim is clear. Then, of course, appointment, the application, the appointment of ARs. So this generally comes into play where there are class operators are there. So it has got its own timeline, T plus 23 basically. So that T plus 23 is, that means we have to file the application for appointment of AR. But remember one thing, the AR name has to be proposed in the public announcement itself, right? So just keep that into the mind. Then comes the report certifying constitutional COC here. That means there are when the report, the question comes in, what will be the T plus 23? Here the practical issue you will face is you are able to verify the claim whatsoever you received it, say by T plus 21. So within 2 days you have to constitute the COC. Question comes in, what is the constitution of the COC? What is the date? You know, how we should understand this, that this is the date of constitutional COC. My advice to you is that send a email to the members of the COC saying it that you are a member of the COC basically, so that mail becomes an evidence that COC has been constituted. Are you with me? And then you based on that you file the report within next 2 days. Now the issue will come that when it will be considered that report has been filed. Generally we are taking into account because nowadays we have to file it on the portal. So the day it is uploaded on the portal, you can say that the report has been filed. So that is what is the technical point. Then comes the first meeting of COC. Remember one thing, first meeting of the COC is linked with the when the report has been filed. Okay, already written T plus 30 days, but if you say that the report has been filed on on the 22nd day, so that means your outer timeline will be T plus 29, not the T plus 30, because it has to be within 7 days of filing the report. It is not a flat timeline we are talking about it. Then comes the COC meeting. You have to call for the COC meeting, and once you call for the COC meeting, you have to present the resolution whether the IRP will continue to be RP or they are going to have the another RP. So the resolution has to be moved. The problem, the challenge which comes in, that if IRP does not continue to be RP, that is the challenge you face it, because it takes a longer time. It doesn't because the application has to be prepared, submitted before the NCLT, adjudicating authority, and they have to pass the order. So which sometime it takes 2-3 months even. 2-3 months even. Okay, the challenges which you face. So the issue which need to be understood is then when you are an IRP and you are getting the COC wants the new RP, then what will happen during this interim period, 2-3 months time, assuming it takes 3 months time, then what is your obligation? The obligation is that we see, although the timeline says that if IRP not pointed by 40 day of commencement of the CRP period, which doesn't happen. So what does it mean? That you become deemed IRP, and once you become deemed IRP, you have to continue to carry the duties and responsibilities of RP until RP gets appointed. And once RP get appointed, you have to basically hand over the charge. So be clear that where the COC decides that you are not being appointed as RP, you have to continue as a deemed IRP, and you have to continue to discharge all the functions of the RP until the RP gets appointed by the adjudicating authority, and only that, and then you have to hand over the charge. So are we clear on this on the IRP side? Can we have the open questions so that that any non-clarity is there, any challenges there, we can address it right now. Yes. Hello. Anything from audiences, or I should go ahead?
Please go ahead, sir.
Okay. So not many questions are there. Okay.
It's all receiving time, sir.
Okay. Fine. I'll just move into see. Let me before I move to the next slide. Okay. Let me just summarize it for the benefit of the audiences. That the challenges you will face is the delay in getting the order. Point number 1. Point number 2. Second challenge you will face is the claim which you received after 90 days time. Third challenge you will face is that you have the caution you have to you have to be careful is that you send the emails to the COC saying the COC has been constituted, so that you have got evidence available. Fourth thing is, okay, whenever you file the report, that the money receipt, you please preserve it, so that you can say that this is the date on which you have filed the report. And because it becomes important, because with the filing the report, the date on which you have to call the COC, that timeline gets linked. And the last is that if you are as a IRP, if you are not getting appointed, you have to become the deemed IRP and ensure and continue to work as RP until the new RP comes in. Up to here, I am clear. And the another in this, when you are not being appointed as RP, it is a normal thing you will find that COC will say you stop the process. Please do not stop the process. You have to behave like a RP. You have to make all the compliances. If COC, even if COC says you stop it, you should not stop it. Okay. So up to RP, I think I'm clear. Now comes the
easy said than done, sir. In the very first month COC itself, they are telling that if you are by OC, the FC is telling that we'll replace you. But the effective order from the NCLT comes after minimum 2 months, even in my own personal case of replacement. But nothing they approve financially, sir. They say that even any appointment of value to anything, they are dodging and they are delaying, and it is really putting the pressure on the IP, sir.
No, there is no need to feel pressure, because this has happened in my case also. I had done very simple thing that what is in my hand? My hand is that I go to the COC, say that these are the values I want to appoint. Correct. I naturally, when I am issuing the notice, I am giving the draft resolution as well. Okay. So what these COC members, I got a choice. Either reject it or defer it. And once they say defer, which is a natural choice, they are going to make it. Then you just record it that okay, this COC member has said that it has to be deferred. In the next meeting again, you place the same resolution again. The idea is very clear that from your side, it has to be proved very clearly that non-compliance is there not because of the IP, but because of the action of the COC.
But they are not accepting, no, sir. Now 3 months are gone, 3 COCs have happened, and each COC, the first COC will not get the opportunity. Second COC, we are placing it. In between also, we are communicating to them and are seeking their approval. They are dodging, they are saying they are giving further more references of valuers and that they are not supposed to do. They are providing that, take further quote from valuers or other parties and even auditors. We are seeking that additional information. But by then, that second COC is over, they have not cleared it. Third COC comes, by then court has accepted that the replacement, but the replacement does not happen by the third COC. The situation is very critical. We are in a really bad situation. The forensic audit also, we have given the court, because there are forensics involved, and particularly transactions, and also even that FC itself we are contesting. So these are very tricky situation, and it's an NCLT appointed case. It's not somebody else who was appointed the case.
So, sir, in my view, let's distinguish the two things that Mr. Narayan Srinivasan and you are saying. One is appointment, and another is payment of fee. Valuer is to be appointed by the RP, notwithstanding.
But with the COC approval, sir, without COC clearing it, you cannot appoint it, sir.
No.
That's where I differ with you. That's where I differ with you.
Mr. Narayan, what the practical way of doing the thing is, actually, Mr. Kanti, I understand what you are saying about it. If you go by the law book,
correct.
It is the fees which has to be approved.
Correct, sir.
But in reality, so whenever you are going to make the fees, it's linked with the appointment, correct? See, only thing what you are saying is practice. If you go by the rule book,
What I am doing, I will be very on. Which I have done 4-5 cases. I'm just sharing my experience, and I'm not saying that either of you are incorrect. I'm just suggesting a way out.
what is the practical way of doing? How you have handled it? If you can share that,
Okay,
then probably
which
we
is
can.
what I was saying, sir. I'm saying
Kanti, once again, you step back. There is a problem that the property itself, COC is contesting that it is not to be brought into the books.
okay,
The
that's
concerned
different.
property itself, they are refusing because it
That's
is they are
different
funded
case.
totally. Whereas the property should have been registered in the company, it is remaining in the partnership of the same promoters. Bank is very convenient that, if it is remaining in the partnership, they are very comfortable. They have already initiated SARFAESI, they have attached it, they are going to sell it. But our contention is they have utilized the funds through the company. We are saying that it should be brought in. So there are complexities involved which has to be taken to the NCLT also. But for which we need to initiate the forensic audit. Forensic audit itself is not getting approved. They are saying we don't want forensic audit itself.
See
This is not a plain vanilla case, sir, Mr. Narayan. This has to be seen in these facts then.
Yeah, but look at it. The appointment of the valuer and the appointment of forensic audit. Okay, even if somebody say that this property is not going to be part of it, okay, even then that is not see, that cannot be linked with the appointment of valuer. It is independent item. This is the way I look at it.
Very well said.
Right.
Very well. Very well.
Okay. Now, when you talk about the appointment of fees, correct? Legally, these are not linked, but practically it is linked, because if you ask your COC that you approve the fees amount, budget amount, right? They will not approve it, and even if they approve it, they will approve it so low that you can't get a good value out of it. Correct? So that practically both issues are linked. But the point which I want to make it from compliance perspective is that without getting disturbed, because in any case you will not remain RP. First point you have to be very clear. Correct?
But
that
RP is going to bounce on you, sir. RP waits for every opportunity that the subsequent coming is appointed obviously by the FC. They are waiting, but we are appointed by the NCLT is not the question, but he is appointed by the FC. So he will like to find out so many of that, the flaws in the previous system. Anyway, it's a challenge.
And it's a challenge. That is why I said it. You can secure yourself by recording everything in the minutes.
So see, two things I was saying, and sir, Mr. Bansal had clarified, and Narayan Srinivasan, yours is factually very different. All I was saying is regulation 27 gives the power to the RP to appoint the valuers and not to with the consent of the CRC. The language is very clear, RP to appoint valuers to determine the fair value and liquidation. It does not say with the consent or without the consent.
So they can be replaced the moment RP comes into the seat. They will be replaced immediately, sir. It's a bit of tricky situation.
That's a risk.
Mr. Narayan, can you give another idea? Very simple. Correct.
Sir,
issue the appointment.
I'm agreeing with Mr. Kanti that we have one of the lowest court. We should intimate, and we are appointing. We can intimate them. But essentially, as you rightly said, the financial approval has not come from the COC. We are in a tricky situation. We can go to NCLT for that. We can file an application under 92 of non-cooperation. But anyway, it is that NCLT, if you go at this juncture, when the first COC meeting itself, they have told that they are replacing the IRP. Then NCLT will see with the colored eye that whether we are trying to take that. It's a very tricky situation. That's what I'm trying to say.
Sir, Mr. Ryan, what you can do is to make sure that you make the compliances. Correct. You issue the appointment letter. You issue the fees what you have, and when you say fees, then you say subject to the approval of COC.
Sir, they have told you get additional people, and they have given additional the valuer and the forensic auditor, and they are refusing to quote. So we are in a, what do you do? So you want to satisfy the COC, you don't want to fight with them, right? So you tell them, you record it in the COC that, yes, your point is taken. We are inviting the additional people. And the third COC meeting, we are recording that, they have declined. So you kindly approve. But by then they are saying, anyway, you are removed. So let the fresh RP come. They do that and we record it in the COC minutes and we can close it. That's the only thing we can do it.
That is all. That is all. Ultimately, we are doing the compliances. No? Well, what we can do is what is possible. What is possible. That's all. So only thing my advice is to make sure that the minutes are clear.
Yes, sir. It is clear.
If minutes are clear, then you are safe. That's all.
Not only minutes, sir. Further follow-up communications because most of the time they were all like the COVID period. So we are communicating only through the mail, and we are keeping on sending the reminders to record that our plea to fulfill the statutory obligations.
That's all. That is all. That is all you will do.
Sir, another thing, sir, as rightly suggested, Mr. Bansal has rightly suggested, and I think you have rightly summarized, Mr. Narayanan. But one thing that I do also, I would like to share, when such issues arise, I individually speak to each of the COC member and take their view. So usually what I've seen that the public sector bank nominees and private sector bank nominees refrain from, speaking very clearly on this, and that comes to your help sometimes. Just experience note that I am saying.
So only one COC member also situation, and anyway, it's a tough situation. We are recording, and for the benefit of the audience also, the discussion really with the guidance of Mr. Bansal that let it go and sink into the audience also that we need to fulfill the obligation while recording every process when it is in we have inability.
That is right. That is what is the right, sir. I'll just go through the next slides now.
You may proceed,
Yeah. Now RP period. So IRP period is clear. So now we become IRP. RP. Of course, the challenge which comes in through the IRP not getting appointed as RP, that we already discussed in length. But my point is very clear that continue to behave like an RP. Okay. Then come the appointment of the valuer. That has to be done from T plus 47 days. So that means it has to be completed within 47 days. It's an absolute timeline. Okay. It talks about it within 7 days of the appointment of RP, but not less than 47th day of commencement. So that means 47 is the absolute timeline which we have to finish it off. Make sure that you appoint it. In fact, to avoid this problem, sometime which I have tried is I get the the quotation from the valuer and put it in the first meeting itself. Because ultimately, if we have got the approval in the first meeting itself, only then you will be able to appoint the valuers in time, frankly. So you should make sure that you have got a resolution for appointment of the valuer in the first meeting itself.
If you are lucky to have all the information by then.
You should. What it requires is only see when you say let's understand that when you say you are likely to have all the information. Question is what information is not going to be available.
Sir, company itself is not in existence for 2-3 years by the time it comes to your lab, sir. And so we are not getting the records even, and no audited financials of the recent 2-3 years are available most of the time. This kind of chronic cases comes, and it's very tough to assess. And after that, you assess that whether the property is belonging to the CD or not itself is the second question. And these are the tricky situations which arises sometimes, sir.
Correct. Now let's take it. My assumption is whenever you are going to have the case, okay, financial statement would be available on the ROC. That is first source. The second best source which I could find is go to the auditor. You will be able to get the financial statement. Number 2, get the valuation reports from the banker. you will be able to know what are the properties are there, which can you can correlate with the index of charges, which is there in the MCA. You will get an idea what are the properties are available and what locations are available. Correct. Once you have got this particular information in hand, which I'm giving a very clean way of looking at the things. Correct. You can invite the courts. Promoter, in any case, you will go on collecting the information from the promoter, but you need not to depend upon the information to be provided by the promoter to get the quotes from the valuer. That is the point which I want to do. Is it practical? In my cases, I have done only that.
Sir, we are also doing it, sir. But unfortunately, this kind of third-party collateral, we can call this as a third-party collateral. This is where the tricky situation and where we have got difference of opinion. Other than that, whatever you said is absolutely fine. We can go by the earliest, the financial file, and we are able to move with that, sir. You are absolutely right, sir.
So yeah, see my way of doing the thing is the day I am get allotted, immediately I write to the banker, immediately I write to the auditor, immediately I go to the MCA. These three sources I pick it up because this helps me for the appointment of the forensic auditor as well as the valuer.
Which is the third source? Promoter.
The promoter, you can't expect. No, that's what I said about it.
So banker
for the valuation report, chartered accountant for getting the financial statements.
And the third source you said?
Third is the MCA. MCA for because if you go through the MCA, in fact then you will be.
But we are actually doing the first process as MCA, because that is the low-hanging fruit before talking to anybody.
Yeah, but yeah, that becomes the start point. Basically, from there you get the contacts of the auditor as well. Okay, and when you go to the MCA, you get to know who are the bankers are there, to whom you can talk.
We are then seeking their access to the ID portal, GST portal. All this we try to do within the first week. So whichever the portal we are able to get those information, we are trying to download and keep it, sir.
Yeah, that is also possible. If you, in fact, if you get an access to the IT portal within the first week, so that also becomes your source for getting the balance sheet also. Okay, so we'll just move into this now. Then comes the tricky the 12A cases, where the 12A cases are there, right? Withdrawal of the application admitted. See, in 12A, the only issue which I challenge, my observation is that when we should stop the process for COC. See, like the withdrawal can happen before the COC is formed or after the COC is formed. The issue comes when we should stop the CRP process. Okay, I have been discussing with some fellow IPs, and they say the day the application is filed with the NCLT, that is the way you should stop the process. But I differ with that because until the withdrawal application is approved by the adjudicating authority, how you can stop the process. So the midway is that whenever you file the application, just make sure that you get an order that the process is stopped, so that you do not end up with any problem you do not end up with any issue later on. So 12A is clear now, the challenge which you are going to have it. Then come the 35A. 35 is regarding the forensic, regarding the avoidable transactions. First thing, the RP to form an opinion on preferential and other transactions. If you see the interesting thing, the logical process looks to be that RP he himself has to go into the financial statements, Based on that, he had to make an observation that these are the transactions which are likely to be a preferential or fraudulent transactions. So logically, it should be that way that within 75 days, you should be able to go through the financial statement and make a note of it. What could be the transaction? What are the likely transactions which are going to become the preferential of the transaction? And then you should go for appointment of the forensic auditor. Forensic auditor is basically for determination preferential of the transaction. I'm talking about the theoretical process. I'm not talking about the practical process. Practical process is generally we appoint the forensic auditor, say that okay, you go through and you let me know what is there. This is what happens, correct? So, but logically, the law expects that RP himself should form an opinion. Based on the opinion, he should appoint the forensic auditor, and once the preferential transactions are determined, then he should file the application within 130 days. Very challenging, but we have to do it. My advice is that file it. Okay.
In this case, I have a question, sir.
Yes.
Like Mr. Srinivasan was saying, usually you don't get the books completed. You might get, in some cases, CD's last financial audited book state financial statement, say for 2 years before or so. Now you don't have the data. Within 75 days, you are not able to get the required data and the books because it's not available on MCA.
My assumption is you will not get the books of accounts. My
Auditor
assumption is that question is without books of account.
How do you form the pay? Because auditor will say I have only the financial statements. I do not have the data. MCA, you will get only the financial statement, which is 2-3 years old, dated. Promoter is not giving. Now, in the absence of data, how do you form the opinion in 75 days?
Okay. What is the methodology you have to follow for understanding that what transactions can fall within the definition of avoidable transactions? You have to be very clear on that. Okay. Now, I'll just simply give you a quick idea about it. Let's talk about section 43. Now, I'm assuming that I have got the only financial statement, audited financial statement, which is 2 years old. Okay, say 22 we are sitting, we have got the say financial statement, which is say 2020. Okay, then I have got the audited statement, which in any case I can rely on that. Correct. After that, if you get the bank statements, in any case we can get the bank statement. There is no issue into that, no challenge. Okay. Then when you talk about a 43, you have to go through the bank statement, quickly see whether any payments are made back to the promoter, yes or no, within the prescribed timeline, within look back period. If yes, you classify it simply. If payment is made to a related party, you classify it. We are not saying that you are going to be wrong or right. What you are only identifying what are the candidates for the avoidable transactions. Are you with me, Mr. Kanti? So
yes, 40, I'm listening. Yeah, I'm absorbing. Yes, sir.
43 is clear. Now let's go to the 45. 45 is regarding the undervalued. So what you should do is you go through the fixed asset schedule, see it what assets has been sold. If assets has been sold, and
fixed asset schedule will of 3 years back.
Of course.
Right.
Correct. But as far as the 3 years, that means I have said, okay, let us take an example, 2020, 31st March. Now 2021 and 22, okay. Whatsoever the closing fixed assets are there, either it should be in your hand, or you should make an assumption that it has been sold. Cover under undervalued.
So I have my physical assets. How will I verify it from the asset schedule of? Because that's a consolidated.
See, you cannot verify one by one. Point number one, without the fixed registering to place.
Correct. Which is
Correct.
why I was thinking, no, I was okay with your banking transaction. Say the
Sir,
bank, from the bank, I can get under 43A, whatever payment has been made to the promoters.
right.
But 45, I am just wondering how would I reach there? But
Okay.
maybe
If you see the heads, the schedule in the audited financial statement, you will find certain classifications are there.
yes.
Okay. Within that classification, generally you will find car is sold.
Okay.
So if you my way of looking
No,
at that, my way of
usually,
looking. See,
usually your heads are land, plant and machinery, building, uh, uh, office appliances, and motor cars. Usually these 5, 6 heads are there.
correct. And
Now,
usually motor car is gone.
but you will not know from that schedule how many motor cars exist. You only know the value.
See, okay. Now next question I would ask you, sir. You have you have always got a right to the promoter.
Yeah, that, yes.
Okay, stay with me because I have handled this sticky issue also.
Yes, sir.
Okay, so there what I have done. Now I will give you a practical example. Inventory, which you will find in every balance sheet. 2020 15 crore is there, and today they will say nothing is there.
Yes.
This is a practical issue, correct?
Correct.
What I have done it, I have wrote to the promoter saying it, look, this is the inventory which I am having. Okay, please hand over the inventory where it is. He comes with the story. Correct.
Yeah.
From the story itself, you can use it as an evidence as evidence. From there itself, you can say whether whether it is a good candidate for you to classify under overdue transaction. And frankly, 2020 balance sheet, if you are in 22, you will not find any inventory over there. You will not find any car also. For car also, if you write an email, then he will say, I got the 2 cars. Then you just make a count of it, is the 2 cars are there. So you have to ask the right question to the promoter and you will be able to find out this 45 also. Is it okay?
Sir, okay.
No,
the major things.
you're not happy.
Yeah, because there is inventory. I don't want to take everybody's time on this, but if there is inventory, he will say there is inventory lying. I don't know what the value is. Now you can't get the value, and then you can't know the discrepancies in the plant and machinery.
Sir, your job is please understand. Your job is to identify candidates for the transactions. It is the forensic auditor job to determine that how many discrepancies are there.
Yeah, so in your inventory, if there is inventory lying up, then how do you know that whether this inventory is 20 or because you don't have sales and 21 and anything. You may be right. I'm not. I'm kind of.
First charge, what first charge you are going to make it? You are going to make 20 crore inventory is there. Then you say the inventory doesn't look to be 3 crore rupees. Then it is for promoter to come back, na?
Yes, you know how the promoters are, so he will never come back. He will not. So I'm just saying that in the absence of data, it becomes very difficult to form the opinion.
No, you have to make your mind clear, sir. It is not difficult to understand which are candidates for the avoidable transaction. That's what I want to make.
All right.
It is difficult to determine it. That how much is the amount. So make these two points very clear. You are as a RP within 75 days. You are just trying to find out the charges. List of charges which you are going to make it. That's all. It is for the promoter to prove it or it is for forensic auditor to help you.
All right, sir.
You got the points?
Yeah.
Just
Thank you.
make the distinction. Once you start making distinction, you will not find it. That's what I want to tell you. Okay.
Sir, one thing I have realized, sir, we are struggling, but so long the COC is with you, most of the time we are getting the supports and we are able to do. But even then, unless you have you also try to get the CD in a good mood to support you, it is becoming highly difficult because otherwise getting the information is very difficult. So that is where they have appointed us. So we have to do a much better human relationship, and PR skills are coming to place.
Let me tell you, Mr. Narayan, Mr. Narayan, is many times because the human relationship we forget what our duties are there. So you have to be clear on what is your next action and do it. That is I wanted to say. I understand human relationship with other things very well. In fact, you will always like to keep the promoter into good note, but he is going to be your friend till he finds that it is benefited him.
Sir, we have to tell that you parallelly most of the time they are talking about 12A withdrawal, sir. The day we enter until we exit, we are realizing that even sometime they are talking about 12A withdrawal, which never happens. Even on very large cases, even COC is getting wooed by them. Even they make some deposits of 5 crore, 10 crore, still they don't perform. So we have to maintain a relationship. Still we keep moving, sir. Take the help of the COC because 19.2 is of no help, sir. That's a personal opinion.
That's okay. That's okay. 92 is 92 is only compliance.
First, go by all these things. Parallelly, you have to do that only to say yes, I am applying, sir. Only to keep my back.
That's right. That is right. So I think 35 is clear. Forensic, we had to do it 75, 115, and 130 days. Make sure that you are able to you're clear about it, the steps, and make sure that it is being done. And if you are not able to do basically because of for any reason, make sure that it is get recorded into the COC minutes. So 35A, timeline is 75 days, 115 and 150 days. Then comes the 36 section regulation 36(1) submission of IM to COC within 95 days of commencement. The problem challenge which you face in the case of the IM is that IM has to be given after only they submit you the basically a undertaking. Correct? So to keep a record of it, when you have done the compliance or not, you should send an email to the COC that I am ready. This is the draft undertaking. You please submit it. Then I will give you IM. So that email becomes an evidence when the IM has been submitted to COC. Are we clear now? Because this is a tricky point. Submission of IM to the COC when it happens. Okay. So then comes the RP period 2. I'm just moving to the next point, the resolution, the Form G. That means finalization of RS. This is a simultaneous process. We have to do it. The Form G, we have to publish it within T+60 days. Generally, you will not find much challenge, but invitation of EUI is basically the process document. You should do it. Be ready for that. And when you are publishing the invitation of EUI, then certain approvals you have to take from COC. Just make sure that you have got those approvals in place before you publish the Form G and invitation of EUI. So both things has to be implemented within T+60 days. And then the submission of EUI, then it's another process within 75 days. Okay, this is the flexible date, but generally, generally if they are given 15 days, generally we give 15 days. Sometimes we give it more days also, depending upon. Okay. But it has got advantage and disadvantages. So, but they have given a 15 days time, but and we should try to comply that we should not extend beyond 15 days as submission is concerned. then provisional list of RH by RP within 10 days from the last day of receipt of EI. This is statutory date. Remember one thing, submission of EI is not a statutory date. That is a flexible date. So within 10 days of the last day of receipt of EI, we should have the provisional list of RH. We have to publish it. Publish it means we have to send a email to the RH, because this email has to go to the all RH, saying it that these are the RH are there. So this and this is a provisional list of RH are there, right? So that has to be on T plus 25, T plus 85 days. That email become the evidence that when you have submitted, when you have prepared the provisional list. Then submission objection to provisional list. If any you are giving 5 days time. Basically, if any objection come in, you have to take into account, you have to account for it. And after accounting for it, you have to make the final list of RS. Make sure that you send the email, because you should be clear about it. See, when you are having the timeline, you are talking about timeline of T90, T100. Okay, how you are going to prove to the IBBI? It's basically only by saying it that this is the email I've sent. So send an email, that becomes important. And with that only you can link it that I have completed my job. Then 36B. And any challenge in 36A from G to final list of RS? And any challenge? One of the challenge is 29A verification. You will have it. Sir, my thought process is 29A has to be completed before you declare the final list of RH. In COC is going to say no, you go for that you go for 29A verification after they submit the EOI. But my way of looking at it, that is incorrect way of doing the things, because once the final list is published, that means it is final. You can't say tell to anybody that okay, you are not eligible for it. Okay, so I'm just sharing now this.
Sir, my view on 29 is we are outsourcing it, sir.
Of course, it is.
We are outsourcing it, and even we are ready to bear the cost, even if COC doesn't bear the cost. This and the preparation of these documents going forward, it will be, I think, IP world that we are waiting for those situations in another few months, the future applications. But until now, that we are going by third-party outsourcing. Sir.
Yeah, that is better also, because third party verification gives you more protection. Frankly,
no, we are doing on our own, but at least we want to have some more external eye so that we are not missing out things.
Correct. Right. So 29 is clear. That is a challenge you will face it, and generally COC will say no, do it afterwards or something like that. But before you publish a final list of RH, my view is that we have to complete 29. So the final list of RH has to be published at T plus 100 days. Then comes the issue of RFRP, including evaluation metrics and IM. T plus 105 days. So please remember, the issue of RFRP evaluation metrics and IM is linked with the date of the provisional list, not the date of the final list. That means T plus 85. So you have what you are getting is on the T85 plus the 20 days time.
Sir, these dates are only for the books, sir. In practical times, getting the papers itself from the previous audited everything, it takes solid 2 months or 60 days or even 75 days to get even the data completed, sir. Minimum I'm talking about. It goes beyond. Even a provisional takes that much of time, sir.
But somewhere you know how you are going to what you are saying, what you as a RP, what you are going to do now. See, if you do not get everything within T plus 100 days, okay, as a RP, are you going to accept it? Are you going to continue to keep it pending, or how you will have it?
Sir, we have to keep moving whatever is possible behind the scenes, sir. But on paper, we have to keep on being prepared for extension of time. Normally, nobody troubles you until that, you know, that penultimate day. So if you are able to crush things somewhere else, it is much easier. If you are not able to crush, then you have to like, you know, go. And that's where this 19.2 and all will help you that, you know, no NCLT, Judge, please see that, you know, we have already escalated the issue. Well, we tried to do these things we could not complete. That's what we have to go to them, sir.
The point which I would make, if 29 is not complete, documentation is not there, then
We are
what
not coming, sir. We are not coming up to even 29 days, sir. We are not able to go to the expression of interest on time, sir. That is becoming the impossible task. EOI releasing, getting released on time
sir,
is becoming impossible.
Mr. Nayan, I have done it. Let me tell you.
You need to share with us, sir.
I have done it. But it requires a lot of you know too many things. You have to take it and make sure that it gets completed. So I'm not saying it's an impossible task, but only the point is that if something is left it out, you make it subject to saying it. See, like final list of RH, if you have to publish it, then you have to say that final list this particular RH is subject to the submission of the documents. That is all you can.
I'm going to wait for you until you reach the 90 days when we would not have got the entire claim also. So I'm going to wait until then. I'll speak there, sir.
Okay. So you can speak, no issues, but generally, you know, ultimately we had to see somehow that you should be able to satisfy to the FBA saying it. I have complied with that. That's all.
Sir,
And
just for the sake of I have complained, I cannot do it. No, sir. We know in front of our eyes that, you know, that the data is not complete. It is impossible for me to go and say that, you know, no, I have given you some data. I cannot do that, sir. When we know that it is incomplete.
Anyway, no comments, but my feeling it can be done. That's all I wanted to say. And I had done it. That's okay. And now, as far okay, 36B issue of RFRP, it is linked with the provisional list, date of the issue of provisional list. Okay, so just keep that into mind. And receipt or registration plan at least 30 days from the issue of RFP. Again, it is a commercial decision. We have to take it, but make sure that it is at least 30 days from the issue of RFP. Common issue which comes into this is the 30-day time is linked with the issue of the RFRP. It is not linked it is not linked with the see, many times we delay the RFRP issue RFP because sometimes we are not able to work it. So do not delay the issue of RFRP evaluation matrix at IM in time. You can always have an opportunity to revise it later on, but make sure that it get it get issued. So that you comply with the requirement. Submission of the COC approved registration plan to A T plus 165. They are expecting 15 days before you are able to do it, and thereby 180 days time is complete, which never happens. Please remember two things. This 180 days timeline does not take into account the second issue of the Form G, because many times I had got a discussion with COC. They were all telling me that you follow a timeline, you have to complete everything T plus 180 days time. I told to them very clearly, then fine, I'm okay with that T plus 180 days, but don't expect me to issue the Form G again. Don't expect that we are going to extend the timeline, and which is a normal process. Okay. So generally T+1 65 is never followed. Generally, I have not seen, and it is a very big challenge, frankly. And let me tell you another practical thing, that if you are able to complete your, submit, if you are able to issue the Form G within the first 30 days itself, instead of T+60 days, generally you will get more than sufficient time to complete everything within T+180 days. It becomes heavy, but it is possible that way. There is no other way. As soon as you will shift to the form, issue of the Form G on the second meeting, you will find a big challenge in meeting out the T+180 days. This is my practical understanding of the subject. Okay. So any challenges which you face it, you can we can discuss it quickly, so that I'll just move into the CRP forms, how they are linked.
Mostly that the claims are coming after the 90th day, sir. So claims are not completed before 90 days. So you said you had prepared the EOI. In those cases, how you have done, if you share your experience, will be great, sir. Would you go by the books of account? What is the amount available? And we are facing a situation that now, as I explained to you, 2-3 years have elapsed since the company had had operations.
See,
so only one point I will ask.
The information
Include and then request your view, sir.
The information
That law of limitation we are crossing by the time, like the claims are even received. So how do we deal with these situations?
See, the information regarding the claim has to be a part of the IM. Correct. IM has to be issued with whatsoever the claim you have received it, and you have always got an opportunity to revise the IM at a later date. So don't hold it. My point is, don't hold it. Whatsoever the claim you have received, put it to the IM, release it, and later on revise it. That is a more practical.
Can you also touch the subject? I have a specific question. Law of limitation, they have breached it. But definitely, like the concern has not operated. Just we have access to the email IDs and we are reviewing their emails and the communications, but we do not know how much physical communication they have given. So how much respect, and as I told you, the books of accounts are not even prepared in the law ensuing 2-3 years. So if let's take a situation, 3 years have elapsed and no books of account there, which is audited financial available with you. It's not a going concern, though in those period. It was declared NPA long back and the initiation has taken time and they have come to this situation. And the FC has not initiated, it's some OC has initiated. So that OC has got a record who initiated, at least there is a legal record that he has created. Other people have not created. What will be the situation for us?
The point is, see, I'm not clear about it. What do you want to do? You are facing a challenge in verifying the claims?
Of course, no, sir. Verifying the claim is one portion. Second is also that that the claim has time barred date, which cannot be accepted unless we have got a record. They prove that they have initiated legal action on that. So all this takes time. We are communicating back and forth.
Actually, I look at it very simple. See, claim has to be verified with reference to the proof of the claim. The first responsibility is of the claimant to submit the proof of the claim. If books of accounts are not there,
no problem. They have given their claim, their reference. Now tell me now that how do we, it's paid or not paid, we do not have a record. One. Number two, that's one portion, leave it. Let's assume that we'll accept the claim subject to
ask them to submit their financial statement to answer account statement.
But
right?
Account statement, we can ask them. It's part of the checklist. We are asking them for the account statement. Yes, we are taking it. Now there is no account statement from our records, and also it's a time barred. So what is your contention? Do we accept based on the claim submission or we go beyond that and see whether the law of limitation they have crossed it, accepted, rejected based on that, or
No.
do we put up the decision to NCLT saying that it's a time bot, should we accept or not?
No, why we are looking at it based on the proof of the claim which they have submitted. Based on that, you have to make a decision.
Decision is what?
You
It's
can.
a time bot. If I'm on the CEO place, I would say, you come after 3 years, you get lost. If I'm the CEO, see, de facto, they are telling me that the RPs of the CEO. I'll tell that, you come after 3 years, go give me that, that you have filed any case or anything, or even a MSME or anything like, you have got a record, you have filed anything against the CD, I ask them, is it correct or wrong?
Correct. You can ask them. True. What you are asking.
They don't give, I reject it, or I take it, they take the matter to the NCLT to decide.
No. And see, why you will take it to NCLT? That's the point which I want to make it. Once they have submitted the claim, you ask the query, you ask for the additional information, they have given additional information. Based on that, you have to take a decision.
Okay, it is a time bound debt, so I can reject it straight away, right? And I can write it, put it on the record. If you got any other proof, you provide it and send it.
That is
the correct stand.
That is the correct stand. That is the correct stand, because ultimately in see the way the things are happening about the creditors. I will tell you in my own case practically. They had submitted the claim without any document for 72 crores. Saying it, all documents are with the RP. They have got a custody. Everything is with him. Hence, there is a claim. Correct. What you will do? You will ask for the clarification. You submitted the claim proof. You say no.
Sir, thankfully, with the COVID, most of the time we are asking them to send the email thing. So most of the time we are recording that, your claim is subject to that, the additional, we keep the, the standard questions, checklist we are keeping. We are responding back to them immediately saying that, these are the things which are missing. Even in case of the deceased, proprietor or the other situation, we are asking them the additional death certificate, everything on individual claims. And in case they don't respond, we are in a tricky situation. If they respond, it is fine. If they don't respond, subject to this, they are rejected for want of information is what we are to record.
Correct. So that is all what RP can do. RP cannot go beyond that, and you can't take a decision based on the judgment, based on the assumption. The point which I want to make it. So you have to go through it, finish, and take your call. That's all. Okay, sir. So I'll just move into this now. Form G, I think I already given you the ideas how to take care of these timelines. Then I will give the CRP form. Okay, 1 to 5. I've divided the forms into 3 different parts. 1 to 5, which is linked to the progress. Okay, so regulation 42. It is provided, and it is a chart which is provided. I just copied it easy for the benefit of it, so that you can just simply see it, what it is. First thing you should remember, within how many days. If you see within 3 days, 7 days, 7 days. So everything has to be filed within 3 to 7 days. First point is very clear. Okay. Now, when has to be filed, that has to be understood. Pre-assignment, within 3 days of giving the consent, you have to file IP1. So actually, that is the start point. If you forget it, still then you have to go back and file the IP1. And what you are going to upload is the consent. That's all. Then CRP1, it is linked with the issue of the public announcement. The day the public announcement is published, you have to file within 7 days of making the public announcement. So the public announcement will be considered as made the day it is published. So CRP1, that means has to be filed within the 7 days of publishing the Form A. Up here we are clear. CRP2 has to be filed within 7 days of confirmation of replacement of IRP under section 42. That 22, that means within maximum 32. See the day. See here again, technical issue will arise. If confirmation happens, very good. If confirmation happens within 1 or 2 days, fine. But if confirmation, because generally they do not vote. If you see in the meeting, they come and they do not vote, and voting takes a longer time. Okay, when you are going to file this particular form, is my way of looking at it. Generally, technically, it becomes effective from the date the meeting has happened, but if it takes a longer time, then what you will do? This is a problem, challenge you are going to face it. So just try to see that the IRP, the voting and all happens within 2 to 3 days time on this particular issue, so that you can comply with the requirement of CIRP 2. Okay, if you are not appointed as CIRP, if you are not appointed as a RP, that means you are not confirmed as IRP, then you have to file the deemed IRP form with okay, you have to file the deemed IRP form from the 40th day. That means 40 plus 7 days, 47 days. At the end of the 47 days, if the new IRP is not appointed, you have to file this particular form. So that means IP1 is linked with the written consent, CRP1 is linked with the public announcement, CRP2 is linked with the replacement of the IRP or conclusion of IRP. We are clear now? Form has to be filled, and do not miss the timelines. This is all about it. So these are, if you see, these are linked with the progress of the CRP. Then CRP3, this is linked with the issue of IM to COC. If you remember, I explained to you, the IM has to be issued. So just the day you issue the email to the COC saying it, the IM is ready and please submit the undertaking, take it that day as the basically date that you have issued the IM. Okay, and within 7 days of that, you have to file this IM. You have to file the CRP3. Correct. Then the CRP4, it has to be issued within the 7 days of RFRP under section regulation 36B. The day you issue the RFRP to the RH, PRH, prospective resolution applicants, you have to make you have to basically file this form. So if you see the timeline and versus these are all linked. You can easily find it out the relationship between them. CRP5, when the CRP is completed. So now, if you are assuming that within 180 days we complete it, that means this form has to be filed on 187 days. Correct? Assuming that this doesn't happen, then what will happen? Other form will come into play, and generally a CRP5 gets delayed because usually within 7 days of the approval, rejection of the resolution plan or issue liquidation orders, either of the event has to happen. Generally, it doesn't happen. After 180 days, it takes 3 months, 4 months, 1 year, 2 years time for getting this completion. Then getting the approval or rejection of the resolution plan or the liquidation order. So generally CRP5 remains pending up to CRP4 is basically within our control. So point which I wanted to make it, CRP1 to 5 is linked with the progress of the CRP. Up to here we are clear, and we have to be clear about the points on which it falls due for the filing. Okay. Then comes the CRP6. CRP6 is linked with the event. Okay. see, the events are already listed over there. Filing of application respect to the preferential transactions, that means for the wider transaction, we have to file it within 7 days of the occurrence of the relevant event. What are the event? filing the application, arranging the interim finance, commencement of insolvency registration process of guarantor of the CD, where I think extension of the period of CRP and exclusion of the time that we have to file it. Premature closure of the CRP, that means withdrawal. Anything happens, then we have to file it, because CRP 5 you cannot file it basically. A request for liquidation before completion of the CRP. That means 180 days period is there, but the everything gets completed within say COC passes the resolution and order comes it say on the 45th day. Then what you will do? You have to file the CRP 6. Because other form you will not be able to file it. Non-implemented resolution plan as approved by AA. If there is non-implementation, again then we have to file the CRP 6. So CRP 6 is linked with the occurrence of the relevant event. Okay. There will be issue regarding the firewall. There is a difference in the CRP 8 and CRP 6 regarding the avoidance application. Avoidance transaction. So CRP 6 has to be filed when you are filing the application. Don't forget it. Okay. So CRP 6 is clear, which is event specific. Then come the 7 and 8. This is a tricky, because 7 comes into play when you are not able to complete the particular activity within time. If you see properly, there are 5 forms are there, CRP 1, 2, 3, 4, 5. So what they are saying, they are given an outer limit to you. That means if you are not able to make a public announcement, say within 3 days time, you have to file the CRP 7. If the RP is not made by T plus 30th day, you have to file the CRP 7. IM is not issued, you have to file it.
I have a question, sir.
Yes.
So now RP appointment is not made, but it is pending with the NCLT. So what we need to report it. Would that report suffice, other than that, not keeping the IM and all, it's not ready. So what do we do? Parallelly, we need to report also IM being not prepared on time.
See, first you talked about the appointment of RP. Correct. If the appointment of RP is not by T plus 30th day, we have to go on filing this. This is the point we are making. But my practical understanding on the subject is, you become the deemed IRP. Once the resolution is passed, you become the deemed IRP, and you start completing the deemed IRP compliance.
Deemed RP, and we fulfill the requirement. But if the information memorandum in that case is not ready, that also we need to file, sir.
Yes. Okay. What it is giving the outer timeline, basically.
Of course, 51, the 51st day we need to file it, right?
Within 51 days we are not able to do it. That means the
X plus 60th day we need to report.
Right.
Or X plus 90, sir.
Sorry?
It's X plus 90. We need to report.
No. See, when you're talking about a column 4, it talks about X plus 30th, 60th, 90 days. That is
no, I'm talking about the point number 3, information memorandum. It's not ready.
Let us first complete the item number 4 first. Okay. For more clarity.
3?
No. Let us talk about the item number 4, column 4. X plus 30, X plus 60, X plus 90 days. Okay. Now, see, let us take an example of item number 5, CRP not completed within T plus 180 days. Okay. So that means T plus 210 days, you have to file the CRP 7. Sorry. If the CRP is not completed within 180 days, then within the first column number 3 will apply. That means by T plus 183 days, you have to file the form.
While
Then
parallelly, you would have moved for extension of time with the NCLT. That day itself, if you have filed it, say about 150th day or 170th day, if you file it, that day itself you should report it, no sir. When we know that it is going to be extended, and mostly COC are helpful, they tell us to go and they extend it. So that time itself, when we file with the NCLT, then we need to report it, or 183rd day we have to wait and report.
See, my way of looking at that, if the approval is not coming, say 188 days, right? Now we got an extension for 90 days, correct? We pass the resolution, say by 160th day. 180 days is complete. We are not received the extension, correct? Hello. I think there is a
Yes, sir. I'm listening. Yeah.
No, we're listening to you.
We are listening, sir.
Okay. So the way, then that means on 183 days we should file it, this particular form. Now
Sir, come to the step point number 3 now. Whenever you can, I'm waiting for that.
Sorry.
Sir, if you can explain
point number 3, serial number 3.
Okay,
when do we file it?
Let me just let me put you on a mark. I think let me see the whiteboard is there. I can write it.
What is column 4, sir?
Let me see whether, because that will become more clear. Is there any way to? I think no way. So what I will do is, let me then explain to you again. Let us take an example. On 160th day, you pass a resolution that 90
please
days extension.
step by step. This I have understood. 183 third date we do that.
No.
Serial number 3, what I'm asking, sir. You have come to the serial number 5. Serial number 3, I'm asking, sir.
That is what I'm coming to the point, sir. 180th day is completing. Say, let's take the date also, so that if 180th day.
Sir, I think I need to stop you here. I request you. The serial number 3 is information memorandum is not issued within 51 days. So it is 51 plus 3 days. 54th day I have to report it, sir.
Correct. This is correct. And after that, after that, okay, you are not able to issue the IM, say for another 60 days time. That means you have to file this form plus this file. You have to file this form on say 84 days. Then you have to again file a form under 114 days until you are able to issue the IM. Are you with me?
Yes, sir. I got it, sir.
Got it? And when you are filing the form CRP 7, you have to write that which is the previous CRP form you have filed.
Link to the current document.
Yeah. So that they can understand within the system that why it has been filed. Basically what they are saying, that if you are not able to complete the activity within a particular date, particular day, then you have to go on informing to the IVPI with an interval of 30 days that what is whether you have completed the same or not. Okay,
fine, sir.
So थोड़ा सा tricky है इसके अंदर, because you have to remember the dates when it falls to you, and especially it becomes applicable when you are not able to get the approval from the NCLT, which
sir,
takes
most of the time after taking the beating, after paying heavy penalty only we are learning, sir.
Yes. So you have to remember that it gets basically it will allow you to file the Form only 3 days before it has fall due for the filing. That means if you have filed at X plus 30th day, so the form would be available only on X plus 27 days for your filing the next form. This is the way it will work. So I hope everybody is clear about CRP 7. This is one of the tricky forms. Then comes the CRP 8. CRP 8 has to be followed on 140th day. It is not linked with what is the progress, whether you completed the work or not. It is linked with 140th day. That means it is linked with the timeline. So that means whatsoever progress you have made it, you have to file it on the 140th. To stop. Anything, if you are not filing it on 140th day, you will have to pay the penalty. So it's clear. CRP 8. This is regarding the avoidable transactions. It is only intimating the opinion determination under Regulation 35. If you talk about the filing of the application, then you fall under this. CRP 6.
I repeat this difference between these two, 6 and 8, sir.
Again, should I repeat?
Kindly, sir. 6 and 8, the differentiation, please, sir.
Yeah. It talks about opinion and determination. There are 3 steps are there. Let me again take it forward, again back to you in this. It has to form an opinion, it has to determine it, you have to file the application. 35A. Correct? On 140th day, you have to report for opinion determination. And filing the application, you have to do it through the CRP 6. I think it's clear now.
Filing the application to AA, you mean to say, sir?
Right. That is what CRP 6.
Right, sir. Got it, sir.
Now you can link it easily with this now, correct?
Yes, sir.
Yes. Let me tell you, because recently I had just come through raising my interim finance. There is a lot, many times the COCs are making the contribution. Correct? It is an open issue whether it will be considered as a raising of interim finance. If there is no money, then CRP cost, you can request the COC to contribute. Correct? Because generally interim finance, they do not allow for the interim finance. Generally, which I have seen, the contribution they make it, whether it should be filed or not, that is an open question. Okay. Should I move now?
Yeah, you can move, sir. The bitter lesson is that, earlier we were all eager when the cases were not there. We were eager and we were going through the NCLT road. Now, after good lessons, we are not even, I mean, I have not even renewed the pledge to go with the NCLT listing, because whatever the case comes there, then you are not getting your money also. So I'm going only with the FC, otherwise I will sit at home and help the other RPs. Since you said the money, no, sir, even with the appointment of NCLT, we are not getting the money other than the first, payment. So it is better that, NCLT cases, you don't accept it unless you are in such a bad shape that you need to accept the case.
Correct. So, and anyway, it works both way around. Probably you may able to get the good case also. It can happen either way.
Sir, let us not hope for the good case. Let us, hope for the case that you can really handle it with comfort, sir. Because without money and without the support also, we are not able to run it. Correct. Maybe the initial starters, that is the best option to get some case. But after you are established, it's better that you work on with your own clients.
So anyway, so 7 and 8 is clear to you. Okay. Then I'm talking about the penalties for non-compliances. If you see, the penalties are there basically 500 rupees per month. Now it is not linked with the rolling 500 rolling month, rolling 30 days. It is linked with the calendar period. So that means if there is a default is there, if you delay it, say by 2 days time, okay, and say your form was due on 29th October 2020, they are written, okay, and you are trying to file it on say 1st of November or 31st of October, there will be a penalty for 500 rupees. So that means if your form is due for filing on say 10th of October and you are filing it on 29th October, you will not be charged with anything. That is what the point is. So, so it is linked with the last day of the calendar month. It is not linked with the linked with the 30 days or 31 days. That is what I wanted to say, right? So we don't have any other option but to go on paying the penalties if it arises. Up to here we are clear. Then come the regulatory fees. There are three from IP perspective. There are 3 types of the regulatory fees are there. From the IP perspective, there is a one type of the regulatory fees there. First regulatory fees is 0.25% of the realizable value to creditors under the registration plan. See, all these fees are payable to the IBBA. First one is payable only when the resolution plan, when the order on approval the registration plan has been passed, and it is payable only if realizable value is that means the amount payable to the creditors is more than the liquidation value. If it is less than that, nothing is payable. We are clear on this. There's no controversy on that. Okay.
So your resolution plan, sir, so what you are saying is your resolution plan can actually have less than the, can be approved at less than the liquidation value also.
There's no bar on that, sir. There is no bar. If you're for
Right, thank you.
COC to approve the registration plan at lesser than the liquidation value.
Thank you, sir.
Okay. Then the second fees is 1% of the cost being booked in the insolvency resolution process cost. Booked. They are talking about the booking. So there is going to be a situation that because this is applicable from 1st of October 2022. There is a controversies are there which says that if a invoice has been raised in say 20th of September and received and booked in the books of accounts on say 10th of October, whether the amount is payable or not, that is an open question. But my way of looking at it, it has to be payable because they are using the word cost being booked in the insolvency resolution process cost. So that means the day we are booking the invoice in our system, in our tally or whatsoever you call it, the 1% is become payable. The second is it talks about hiring any professional or other services.
So this 1% to be paid from the CD, I mean that the company, or will it be paid by the RP, sir?
It will be payable by the company. So
by
CD only you are going to take it, sir.
Okay.
And so sir, second part, just when I am engaging an IPE for services, then that 1% has to also go.
Logically, yes.
Obviously, yes. Obviously, yes.
No, I'm asking Mr. Bus.
Yeah.
My opinion is yes. Because it's going to be paid by the CD, Mr. Kante. It has
So
to
the
be booked onto the CRP
point
cost.
So point that I'm trying to make, Mr. Bansal, is where, like in your firm, you are the partner and you got an IP assignment, you are paying 1% out of the fee that you received, and you also pay the fee that 1% from the revenue that you share with the IPE.
No, it is wrong, sir. It is wrong. 0.25 only from your pocket. That's what I asked.
Normally what it happens, let's take it practically.
Yes, sir.
Say let's take it 2 lakh is the total fees. Okay. You agree that IPE will keep 60% or say 60%, then 1,20,000 has to go over there. So generally what it happens, the IPE raises the direct invoice.
Is it?
IPE you specifically covered. Maybe Kanti,
Okay.
Mohan sir has to wait until you
raise the direct invoice, correct? You are booking
IPE does not raise the direct invoice, sir. You received as an IP and then you share it with your IPE. The way you say.
If I receive the full amount, okay.
Yes.
And then I'm paying out of my pocket for that. I'm paying for the personal account.
Yes.
Then very the applicability of this, sir.
But you are hiring because IP is rendering certain services. I'm saying.
See,
although you are not booking it.
No. Are you saying that if I hire an advocate, okay, and I'm paying out of my personal account, out of my own fees?
I'm asking you what is the right way. I'm not giving any answers at the moment.
the point which I wanted to make it, sir. Nothing is applicable if I am paying from the personal account.
All right.
It is this 1% and all come into play only and only if the IPE cost, IP is raising the direct invoice and it is being moved in the CD account.
Now the second question is in view of that latest circular where I think we cannot engage IPE or something that sort. What would be the?
We cannot engage. No.
If I am a partner, is there not some circular that has come recently?
No.
Okay, then I'm mistaken.
If so long you pay from your pocket, you can appoint everybody. If you are going to take it from the CD, you cannot appoint it unless it's as a package. You take it. Going forward, the future cases are only going to be IPE cases.
Correct.
So this is where I was coming to. So if IPE cannot raise a direct invoice on the CD now, right? If I am the IP.
No.
If you are appointed together, the IPEs are appointed together on the appointment. Even in the past, it has been done. So in that case, the fees are separately paid for the RP on individual capacity and IPE paid individual. I can give example, live example also.
Right, sir. Right, sir. No, I'm not arguing and taking its time. I'm just trying to understand how things should go.
Correct. In that case, 1% has to be paid on IPE fees as well, because you are hiring for assistance by the IPR. So up to here we are clear now. Then 1% of professional fees, whatsoever the billing we are raising it, we have to pay the 1% for that. That is also clear. And
so this got nothing to do with any other service, like what about the transaction auditor? What about the valuer? All these are not getting
transaction. No, transaction auditor, and if you are engaging the transaction auditor, that becomes the payable as a cost being booked in insolvency resolution process cost, as a part of CRP cost. Once you are engaging the valuer, in any case, you have to pay directly from the CD account. If it's a forensic is there, you are going to pay directly from the CD account.
They may or may not be RP, no, sir. But I agree that valuers are going to be IBB approved valuer, but they will come under a different regulation, not in this, no, sir.
How the regulation makes a difference?
No, where is it saying that engaging the other professionals?
It says other services.
They're saying hiring any professional. See, when you are hiring the valuer, you are hiring the professional.
Transaction auditor, for instance, may not be IPV approved.
No.
In that
Everyone
case
gives
also you
answer.
need to pay.
Sir, IBV, it's they are see, it is not the IBV approved. We are talking about it. You are talking about hiring any professional or other services. So what is it essentially? If you are going to hire the advocate,
That
are
also
hiring
payable.
professional,
Sir.
na?
Advocate is also payable, sir.
Yes.
Yes, it is payable.
But it
Sir,
is being
also-
hired by this COC. There are multiple advocates come into play. In large cases where we are handling, we have got the advocate fee representing RP, advocate fee representing CD, defending the cases which are pending or which we are pursuing. And there are advocate fees paid on behalf of COC also. So how do we differentiate this?
See,
All are to be paid.
Let me tell you, you cannot pay the advocate fees on behalf of the COC. That is a clear violation. That is a clear violation.
That is clear violation. So that
up to we are clear. Now we are left with the fees which is paid for the cases which are relating to the CD business or correct, or the matters which are relating to the CRP process. Correct. My way of looking at the thing is, they are saying that cost being booked in insolvency resolution process cost. That is anything which you are booking in the CRP cost, that becomes the benchmark for decision whether you have to pay for the 1% yes or no. Okay. Now let us take an example that you have to deploy the security. Okay. So there could be a situation where there is a running business is there. Then security cost is being paid out of the inflow of the CD itself. You are not going to report it as a part of the CRP cost. So you are not going to pay the 1%. This is my way of looking at things. But if
otherwise, if they need not be professional, no, sir. It's other services. So it will come under the other services which you have mentioned.
Correct.
So it will have to be paid on that amount also. It's a very mind opening, sir. It's important to know, because the first day onwards we are starting to recruit people for the security to protect the interest of the CD assets.
Right. So but on the benchmark according to me is that basically, if you are booking as a part of CRP cost, that means the CD doesn't have the money. So you have to book as a part of the CRP cost. Correct.
Correct. But the COC will have to shell it. I agree. Or out of the assets, we are going to pay it out as and when it comes. Now, this cost, whenever we book it, when is it payable, sir? Now, for example, you give us the right example. When the appointment happens, or when the payment happens, or after the payment, 1 month later, or what?
See, the resolution plan, the costs which are you see linked with the resolution plan, the item number 1 and 2, these are payable quarterly or on happening of the event. See, okay, let us. I think I have plotted it.
Sir, the first point 25%, 0.25% we are paying only at the year end, no, sir. We are not paying.
No. It is linked with when the resolution plan gets approved.
No, even otherwise, by end of the year we are calculating and we are paying also, no, sir.
No, how can you pay it?
But year end we are paying that 0.25%. It's not the same as this.
No, 0.25% you are paying on the
our revenue,
the IP fees, our fees, which has already gone to 1%.
Okay, that is fine.
It is covered in item number 3. It is not.
It is not covered under 0.25. Okay, 0.25 is as and when the occurrence.
As and when the registration plan gets approved.
Okay.
Sir, can I ask a small question?
Yes.
Based on what you said, that IP will raise the invoice. Are you telling me, as per your slide, that IP will first pay 1% on what it invoices it makes, and then as per your bullet 4, it also pays at the end of it 1% on its turnover?
Correct.
Okay. So it essentially pays 2 times, because that cost is also part of its turnover, whatever it is booking as invoice.
So one is IP, one is IP, no, sir.
No, sir. If you see your regulatory feed bullet number 2, you said when I engage my IPE, the IPE invoices the CD and therefore it pays 1% on that.
Correct.
And then at the 4th bullet, you are saying IPE is also paying 1% on its turnover every year on 30th April.
It is a fact.
Oh,
It is a
that's
fact.
all I was trying to get a clarification from you.
It is a fact. It becomes double
It's the
charges.
same amount, which if the IPE invoices will have to be paid twice, 1% first time, second time at the 30th April.
Correct.
No,
correct.
but paying hands are different. One is paid from the IPE hand, one is paid from the CD as a process cost from COC.
No, not clear. What you said the last.
There are two fees, no, sir. The one fees of IPE, whatever he receives, he will pay it as a routine. 1% now it has become, so he will pay as an
Correct.
RP or IPE. It
Correct.
makes no difference. 1% they pay.
Correct.
The other 1% which has to be paid is from the CIRP process cost 1%. So essentially, it is 2% for the IBBI hands.
No, actually, no. In the IBBI it gets 2%, no doubt. Okay, 1% which is being paid. Okay, 1% which is paid as on the professional fees. Professional fees. Let's to make it on the services, basically what you are paying, the IP services, correct? That becomes a part of the CRP cost. So basically,
sir, we are not claiming it from CIP process cost, no, sir. 1% whatever we are receiving it.
What we are receiving, we are not.
We are not booking it. So whatever is paid from CRP process cost, 1 more percent we have to add.
Okay, I think I need to simplify more, basically. Okay, let us take it item number 3, second, third, and fourth. Sorry, together. Okay, whatsoever the IP is billing, we have to pay 1%. That at the year end. You said on or before 30th of April. Up here we are clear. So there is no non-clarity is there. As far as IP is providing the services, we have to pay 1%. Full stop. Annual payment, we have to make it 1%. Up to here we are clear. This 1% was 0.25% earlier, which has been increased. Up to here we are clear. There is there should have been non-clarity. Correct. Whatsoever the IP, whatsoever the IPE was charging earlier, they were paying the 0.25%. Now that 0.25%, they have virtually, if you see in the right manner, that has been increased to 1%. Now let us talk about the other professional services. That means if I advocate and if I use the IPE for giving me the services. Now in that case, what they have made it, that will be covered under item 2. And that will become payable by the IP every quarter. Point number 2. Okay. And that 1% will become the part of the CRP cost.
What in a situation where there is no cash flow in the company itself?
We have to pay.
You have to beg COC like we are begging our fees.
That issue I am also facing, but and that issue was raised. Nobody has got an answer, but my way of looking at this, if you are going to make a default, suppose, correct?
No, sir. I guess the best way is the way there is a concept of performa invoice in GST, where you don't realize the money you can give through, at least bill it through performa invoice. We should bill it through performa invoice, and whenever realize, then we will pay it.
Sir, please remember, there is no question of billing it. I'm not going to receive this money in my account.
No, sir, it's not about that. It's about whenever you are paying to the IP for its services, one is due and one is when you are paying it. So when you are paying to them, you can pay to the IPBI.
Sir, you are talking about IPE, correct? What about the professionals?
Same situations are professionals. Lot of valuation report is given long time back where the payment happens after a year in true sense.
Hmm.
So
After
whenever
that,
you are paying to the valuer, pay to IBBI for their services.
but they are not using the word. They are using the word cost being booked.
Sir, unless Ravi sir, unless we book it, we are not going to get the money from COC. No, we have to place
Not at
that
all,
to
sir.
COC. That
In
is the time it
COC,
is.
sir, in COC, what we do generally is we present the estimated cost and get it ratified. So once it is ratified, doesn't mean we get the money. It's we have ratified as per the IBBI law that once it is ratified, you are deemed to be paid by the COC for under and treated as CRP cost. If it is not ratified, you have to go to NCLT for ratification if at all there is an issue. So in
Correct.
that situation, boss, till the money comes, how can I be able to pay to IBBI?
Let us take that. If there is no money, I have to take contribution to the COC. Then what you will do? Then the all members are going to say, you give me the invoices.
See, it's not only you. The COC members are also going to be in default in this case if they don't make the payment. So you don't
Sir,
worry.
let's be practical, sir. They damn care about
I
it.
disagree with you, sir. Because IP regulation puts a responsibility on the IP for deposit of this particular.
Exactly, sir. So COC is doesn't care about those default and all. They damn care about it, sir.
Correct. So
So the point is very.
Yeah, please.
The point is simple, sir. I believe, yes, IBBI has regulated us that we are supposed to, means ideally, we are supposed to, we are given the responsibility to deduct the money or add that money of 1% over the professional services and pay it. So basically, whenever now we are going to get it ratified from the COC, this whatever the value of services we are getting ratified, plus 1% will be added. And whenever the money will be coming, we will deposit it into the IBBI account. It's as simple as that. I don't think so. Any other way we are, any other solution is there for at least IPs. I have, in one of my cases, 3 times we have gone to the court and court says, what we can do, you also know COC doesn't pay. So courts themselves show helplessness in these matters.
Correct. But the only question which you are trying to address it, sir, whether the payment we should deposit it on the day we book, we are getting the invoice and putting into our system saying that this will become part of CRP cost. Okay, let's take a practical example. The resolution, the order for resolution plan get passed, right? On that particular day, you have to report the CRP cost. Now, once you report the CRP cost, essentially would mean that you have booked all the costs. You cannot say that that I have not booked it because you have reported it. Means you have to book it. Only then you can report it. Okay, and say some invoices are unpaid because why? Because you don't have money in the CD account. Then what you will do? A question would come in 1%. Whether you will on that particular whatsoever the unpaid amount is there, that on that also you're going to have the 1% added.
Sir, very simple, sir. In my case, instead of fighting it out, it is normally like 1 lakh to 5 lakh is going to be this kind of cost. I'll book from my pocket, I'll invest it, and I'll pay it and seek that the COC to pay me.
It is not even, yeah, it is not even 4 or 5 lakhs according to me. Even if you have got a 1 crore cost.
I'm just saying, normally it is not so big. The cost that we are talking normally.
Normally, that is what I wanted to say. Normally it is the IP fees which form the major part of it.
Correct. So better you pay it and reduce from your revenue. So much of revenue you have received less, you book it and close it.
Correct. That's the way I also think that way, frankly.
Sir, can we take a small break, sir? Is it okay for you to take a 10-minute break? Normally we take.
No, I have got only left with one slide, and then
go ahead, sir. Go ahead.
I got left with only one slide. the compliance certificate, Form H. Form H is, of course, I'm not going to give you too many details. So Form H is a standard form which you have to fill it up, saying it that what activities has been done and which has to be reported. And it has to be filed along with the application part. Okay, I think I've got 3 more slides. Either because 2 I have to 317 in there. Okay, so if you wish, we can break it for 5 minutes, no problem, because I think this will take some disclosures.
It's better we come fresh to listen to your fresh information, sir.
5 minutes, but yeah, because
10 minutes will take it, sir.
Yeah. Okay,
Parveenji, I suggest you take a 5-minute break and you try and wind this up, by 3:30, because
it has to be more, it has to be finished before that. Or if Mr. Ryan, if you allow, we can just simply close it, because I don't think so. It will take too long.
You can go ahead, sir. So please, if everybody
because we are left with the relationship.
We'll continue with the session, sir.
Yeah, because this we are doing it day and night. Only thing I will give you some technical issues which are going to come in, instead of giving you too many details. Okay. First is relationship of IP. Okay, whenever we get appointed IP, we have to give a disclosure within 3 days. Okay, what is our relationship with the CD? Okay, actually, if you see the relationship, the disclosure, there are 2 types of disclosure we are talking about. One which I have to file, which the professional to whom I am appointing has to file. When I'm talking about the professionals which has to file, that means what a duty, the way it works is, whenever I issue the appointment engagement letter, I give them the letter of disclosure also, so that they sign it. Okay, they give it to me, and based on that I file it with the IPA. The point which I want to make it, whenever you make an engagement, please ensure to get the letter of disclosure also. That is the point which I want to make it from the other professionals. Otherwise, you will find difficult to file this particular disclosure. Okay. Now, first you have to understand that when the disclosures are to be filed, when the relationship of insolvency professional with corporate debtor, when within 3 days we have to file it whenever we get appointed. That's the first immediately we have to go to it. Whenever we appoint the valuer or the accountants, okay, we have to again file it for the appointment. But at the same time, we have to appoint, file the letter, file the disclosure of the other professional as well. So it gets triggered that way. So it becomes a little complicated, because under 2 only, whenever you are appointing registered valuer, accountants, legal professional, other professional, you have to take a disclosure and then file the basically that disclosure with IPA. When comes the financial character, whenever the constitution of COC is there, you have to just simply file it. What's the disclosure? This is with regard to insolvency professional. Interim finance provider, whenever we are having it, whenever we are signing the agreement, you have to file it. PRA, similarly, whenever we are giving the IM, we have to file the this particular disclosure. So if relationship with any of the above come notice arises subsequently, then you have to file it. The point which I want to make it, when you have to file the disclosure, whenever you are, when your own appointment done, whenever you're appointing any professional, whenever you're constituting the COC, whenever you are having any agreement for the interim finance, and whenever you are giving the IM to the PRA, not to COC, I'm talking about PRA. So these are the events with which the disclosure is linked. So that has to be done within 3 days time. Okay, this is basically a chart which talks about it. The other professional, it has got the same flow. It has got the same flow. So that means whenever, say for example, whenever you appoint the say valuer, okay, that time you are going to say that you are going to say that you'll provide the information whatsoever available with you, and you expect the letter of disclosure is there, and based on that you're going to file this document. Okay, Then this is nature relationship. Remember one thing, it is not 524 which become applicable. It is the nature relationship is already defined under A, B, C, D. There are 4 kinds are there. First is basically linked with the gross revenue. Okay. The second is linked with the relationship with the shareholder, director, or KMP. Third is linked with the related party of the insolvency professional or other professional. Fourth is linked with the income. Okay. Where the insolvency professional, the professional is the case may be partner and director of a company, firm, or LLP. Then it talks about the see, the fourth one is basically comes through the entity. Basically, when an entity has got a relationship, only then D come into play. The point which I wanted to make it, sir, A and B talks about the linked with the income. B talks about the personal relationship. C talks about the related party relationship. 4 talked about the company relationship. Simplest way I can explain to you. So whenever so that means these are kind of nature of relationship which is going to there, which has to be disclosed. The next comes the remuneration plus cost disclosure. Remuneration is, of course, everybody is aware about it. It has to be filed at two stages. One is whenever the IRP's period gets over, then we have to file the cost disclosure, remuneration disclosure. And whenever IRP period is over, or whenever RP period is over, we have to file it. And whenever similarly, it is in the case of the cost also. Okay, I'm just running through quickly into this. So any open question there, I can simply discuss about it. These 2 types of disclosures. Answer. Answer.
So I think what we can do is probably we can take a 5-minute break. It is 24 minutes past 3. So let's reassemble at 3:30. If that is all okay with you. I think it's a too short a break, but I think because we don't have time, so I think we need to rush through this. So let's reassemble at 3:30 and we'll resume with the session. Thank you so much.
Your session, you're going to resume it, correct?
Yes, I'll resume. Praveen ji, you can please carry on. Thank you so much.
Yeah, because thank you very much.
Yeah, you have a hearing and all the best for that. It's a resolution plan.
Yeah.
Yeah.
Okay. Thank you very much, sir.
Thank you so much, sir. Nice. We enjoyed your session, sir.
Thank you very much. Sir.
Nice sharing, sir.
Okay. Bye.
Kindly share the PowerPoint presentation also with us.
That will be done, sir. In any case, that will be done.
Okay.
Shall we start? Do we have the participants back in the virtual meeting room? Can Trishla, can you please
Yes, sir.
can you please confirm if the people are back so that we can start again?
Yes, sir. Yes, sir. You can start.
You can start.
Sure, sir.
Let me see a few faces.
Sure, sir.
Let me see a few faces. Let me see actually that they are there. Yeah, I can see Mr. Goyal. I can see Sanjay Khandelwal ji also. Good.
Present, sir.
I can see Srinivasan ji is also there. So is Mr. Bagri. So yeah, I think we have a few active participants who are back. So on that note, let me take off from where my illustrious partner Parveen Bansal ji left. The topic that we were covering were twofold today. One was on the compliance part, the compliances that one has to do through, under when the company is going under CIRP and you are functioning as IRP or RP. Parveen ji very diligently took you all through the kind of compliances. There was a lot of Q&A that also happened while the session was on, and I think it became very fruitful because sessions which are monologue generally tend to be a little boring. And if you add the factor that the session was taken between 1 to 1:30, sorry 3:30, that's the time generally post lunch people are a little bit lethargic. So I think it was important that there was participation. And the topic that I am going to dwell upon is essentially about managing the CD when it is under CIRP and when it is a going concern. Now the topic is very, very interesting because there is no one set of rules or do's and don'ts that one can follow when the company is functional, when it is a going concern. Managing the CIRP is really a challenging task because there are many moving parts and you have to manage all those moving parts. There are many variables that are acting in place in tandem. So you as RP, you have to have a lot more skills than just the skills that one would learn either as solely as an auditor or solely as a compliance person or solely as an advocate. So it is like a amalgamation of a lot of skills that would be put to place. So I'll begin by sharing the presentation that I've prepared for this particular session. I hope the presentation is visible to all of you. Is it visible?
Yes, sir. Yes, sir.
Yes, sir.
Yeah, so let me make it full screen. Just give me a minute. View. Where is view? One second. Yeah. All right. So as you can see, one thing which I am a firm believer in is that a picture is worth 1,000 words. And as you can see, the picture of that gentleman on the right hand part of the screen, he is not any divine person, Ashtabhujha kind of a person. He's not a devata. He is your quintessential insolvency professional trying to manage the CD when it is a going concern. So that's the kind of role that you as IP would need to perform when it comes to managing the CD if it is a going concern. There are many roadblocks in the process. There are many challenges in the process that one has to follow, one has to overcome. And it is important that we understand those roadblocks, we understand the challenges which are going to come and stare us right in our face when we perform our role as IP in a going concern. I'm going to be talking more about my own experience, as an RP of a going concern with more than 3,000 workmen and employees who were working. There were 2 units which were functional when the CIRP started. So I will be drawing a lot from my own experience, and I would want people and the participants who have undergone such a situation to also share their experiences and their thoughts, because I think the forum is a good forum for all of us to kind of understand from each other's experiences and enrich ourselves. So I would urge participants to also pitch in with their experiences, their unique experiences wherever they find it appropriate. Right. So I am talking about the roadblocks. I think the first roadblock that you would face when the company is still functional, the fact that the management of the company, personnel in the company, they would be certainly loyal to the ex-management, to the ex-promoters. And to expect them to shift their loyalty to you just because you have been appointed as an IRP, RP by Honorable NCLT is a legally tenable argument. But practically, I don't think that really works. Because if you straight away start going ahead with the fact that you've been given a mandate and you throw your weight around with the fact that you are a court-appointed officer, in my own humble view, that is going to create a few more roadblocks for you instead of overcoming you or helping you overcome those roadblocks. Because your role as RP of a going concern is similar to the role of the ICU head in a hospital in which a patient is admitted. Much of the vital parameters of that patient are fluctuating very, very dangerously. And it is your job as the ICU head to ensure that the patient survives, that the patient heals and gets rescued. So not everything that is written in the code becomes, or captures the scenarios which present themselves to you when you, act as RP of a going concern. So what should you do? Those are the questions that we need to find answers to via this discussion that we are going to have today. The second roadblock that you're going to face, which some of you already alluded to in the first half of the session today with my colleague, was about the reluctance to share information with you. On one hand, you are required to do all the compliances, and on the other hand, you have a situation where people are not giving you information, people are reluctant to give you information, people are always dilly-dallying when it comes to providing you with the information that you are seeking. What would be your modus operandi to overcome such kind of a scenario, such kind of roadblocks? Nothing of the sort is provided to us in the code. Nothing of the sort is provided to us in the regulations. They are only giving us a framework.
So they have in fact given negative, sir.
I would not say.
The moment you slap it, the relationship is going to be bad to us.
Exactly. So I think, so this is where what I'm going to discuss. How you and at what stage you invoke which thing, particularly when it comes to a going concern. See, you are, you're not, first and foremost, you need to forget that you are a chartered accountant or you are a company secretary being a chartered accountant, your key role is to do audit, to find mistakes. As a company secretary, your key role is to do compliances, to ensure all the compliances are done. If you go with that kind of singular minded mindset, I'm afraid the patient is going to die. The patient is going to die. He's not, or she's not going to survive. The patient would require a lot more dexterous handling by the handler, who in this case is the IP, for ensuring that, or in ensuring that the patient survives. So we are going to talk about it. How do you overcome these hurdles? How do you overcome these challenges? Is something which actually is something that either one learns through one's own experience, or if one has undergone some kind of a formal training in management, they are then, it is possible for them to have those kind of tools with them at their disposal, so that they can use those tools to overcome these kind of issues that come up. I would club those tools and call them behavioral interventions. Basically, they are traits that you have to develop in your personality, which will help you overcome these hurdles. The point is, what are these behavioral interventions? When do we use them? And how do we use them? So in my humble opinion, through my own experience as an IP who handled a going concern, as a management professional also, as a student of management also. So I have tried to put together all those thoughts, all those ideas, and try to share it with you. I'm not going to say that these are gospel truths, because these are not, or these are not something that can be casted in stone that this is how things will work. No, these are my experiences as a professional. These are my learnings as a management student that I thought I'll share with you. Okay. Somebody very rightly said that the moment you file a 192, 193 application, the situation would kind of turn to worse from where it was. It is rather going to aggravate the situation and not solve it. But our legal eagles, the legal support that we have, they present 192 and 193 as the be-all end-all. Of course, it is the be-all and end-all as far as protecting the skin of the RP is concerned. If you don't file 192, 193, then the buck will eventually fall on you. So you have to file 192, 193, but at what stage you are going to file 192, 193 becomes critical. So I have kind of divided the period of CIRP into 3 stages when it comes to managing the CIRP as a going concern. And I'm constantly reminding that this is specifically true when it comes to a going concern, a large company with functional units, with functional managerial teams. So you've got to divide the CIRP of that into 3 stages, in my view. Stage 1 is roughly from day 0 to day 45. This can be actually shrunk to day 30 also, depending upon situation to situation. Stage 2 could be from 46th day to 90th day, or from, if somebody wants to have it a little early, then it could be from day 30 till about day 75, and the third stage is thereafter. And what do I call these stages? I call these stages as stage 1, easing into the role of the RP. You are just easing into it. You are stepping into the shoes of the board of directors. You are placing your own people in the key positions in the corporate data. At the same time, you are not antagonizing the existing tier 1 and tier 2 management in the company. And I'm specifically, telling that tier 1 and tier 2, because tier 2 is the most important as far as the RP is concerned. Tier 1 is important in the initial part, but tier 2 becomes very important throughout the CIRP as far as the RP is concerned. Stage 2 is when you consolidate your grip, and stage 3 is when you're fully in control. So these are the 3 stages. If you try and put stage 3 first, try and take the control, fully in control, try to get that, I'm afraid it is going to create more problems for you. So in my view, these are the three stages in which you have to operate. So what are the behavioral interventions? Stage 1, when you are just easing into the role of the RP. So I have divided those things into what to do and how to do. What to do? Identify the people. You should be in very, very quickly, in very little time, you should be able to understand who are the key people in the company, their position, their proximity with the ex-management. You have to make that judgmental call also. Usually there are 3 levels of management: the innermost circle, the most trustworthy circle of the promoters, the second level of the management, and then the third level of management. So your formal communication, the legal communication, has to be with the innermost circle of the CD, innermost circle of the ex-management of the CD. And mostly informal and largely informal with the second and third level management of the company. You also need to have a keen eye and keep looking for people who are disgruntled, yet talented and frustrated from the top management. You have to try and develop trust with these guys. They are the ones who are going to be your khabri lals. They are the ones who are going to give you information about the company. They are the ones who are going to help you form opinion on the avoidable transactions also, in absence of information and data, formal data that you get. But generally speaking, these kind of things are not very problematic when it comes to a going concern, because there is a functional auditor, there is a functional person who's keeping the books, there is a functional company secretary who would be doing the compliances. So these are the people who are going to provide you with all the information that you are looking for. You need to be present and be seen. You cannot be operating like a remote person. You need to be present and you need to be seen. And how do you do all these things that you need to do? You must have a zero adversarial approach. CD is not an adversary. Even the management, ex-management of CD is not your adversary. You are a placeholder, and you have been entrusted with the responsibility to run the company by a court order during this intervening period. So be very clear about your role. You must also be considerate of the fact that people, particularly in the tier 2 and tier 3 level, they are facing utmost uncertainty in their careers. The company is already under insolvency. There is no guarantee whether it's going to survive. There is no guarantee if it is going to get liquidated. There is no guarantee, even if there is a resolution, whether the new management is going to retain the employees or not. But at the same time, it is imperative upon you as the RP to ensure that the company continues to function as a going concern. It doesn't stop. And the most important thing to do that is to ensure that these people who are in tier 2 and tier 3 level of management, they are getting reassurance from you. You have to show them the empathy. You must tell them that yes, situation is uncertain, no doubt about that. But you are trying your level best to help them tide over the situation. You are trying your level best to ensure that the company survives. That communication you must do with these people. But don't overpromise and underdeliver. Don't promise something that you cannot accomplish. I think the best way to put things across is when you say that I will try. I will try. You need to have, by and large, an easy demeanor. You need not be very stiff. And you should be mostly in the listening mode. Mostly in the listening mode. Listen, listen, listen. Just listen to what people are saying. This is certainly not the stage, in my view, to file 19.2 and 19.3. Because this is the time when you're still trying to get the information from the ex-management. And in any case, if there are professionals in the company, if there are people in the company who are salaried people who are getting the salary where you are going to be signing the check, then I think by and large in this period, they are able to understand the legal position also and the practical position also. The legal position is that nothing moves without the approval of the RP. And the practical position is also the same, that their salaries and everything gets done or gets paid only after the RP signs off on them. So with these two facts, at least the top people who are the top management people, if you do formal communication with them, more often than not, they will provide you all that you need in terms of preparation of your IM, in terms of making an opinion on the avoidable transactions, helping you make an opinion on them, and also in helping all the data, all the information to be provided to the forensic or the transactional auditors. Let's come to stage 2. Well, this is the stage where I believe you will be very clearly understanding whether and how much of information you are getting. You would be able to do some of the basic stuffs by then. The most important thing to be done, and this can be done even in stage 1 also, is to form different committees in the company. And when I say committees, I mean committees to evaluate the price related things, committees wherever money is involved. Wherever money is involved, if it is a buy decision, if it is a decision related to selling, pricing, etc., you need to you need to form committees. You need to have the key people from different departments heading or making those committees. That committee will approve or will recommend a particular decision to you. And then you are going to sign off on that decision. You are not going to sign off just like that. It is only going to come through a committee. And you are going to make those people in the committee responsible for their actions. This way, even you get protected, that all the calls that are getting taken, whether it is the buying thing, whether it is related to any vendor payment, whether it is related to anything which is to do with the pricing, all of that gets signed off by the management, the existing management team which is there. It can also include ex-directors, by the way. It depends upon situation to situation. If in certain cases, the decisions were earlier taken by the ex-directors themselves, so have that ex-director also in that committee, have some other 2 or 3 people down the line also in that committee. Be very particular about adhering to the new reporting processes that have to be followed. The new reporting processes that have to be followed, you have to make that very clear. Of course, by this time, you already would have placed your own person in the key positions in the CD. Those people who are in the key positions in the CD, particularly in the finance and accounts team, particularly in the MIS team, where all the management information system gets generated. These are the places from where you're going to get a lot of daily reporting. Have a dashboard kind of a thing also, if it is possible. Ask as many questions as possible. As many questions as possible. One, that will help in your own understanding. And second, it will create a sense and a feeling in the people that you are trying to understand. And there is no, should I say, for an employee, if there is a person who comes and keeps asking questions, who is in a position, which is the position of board of directors, then believe you me, the profile of that person in the eyes of people increases and gets enhanced. You have to show respect to senior employees. Arrogance is the last thing that you can afford. You have to make yourself approachable. By now, you would already have identified and build relationship with some of the people whom you can trust. Of course, you have people that you have your own people whom you have placed at key positions, but you have to develop trust with other people as well. And this is the stage when you also start showing some teeth. This is the stage, if people are not cooperating with you, you let them know that there are provisions in law that will help you in getting the things done and getting the information through a legal way, where there could be penal action against the person also. Except for the ex-management or the directors, promoters, and 1 or 2 other key people who are in their innermost circle. For every other salaried person in that company, this threat of 19.2, 19.3 is a big threat. They will start cooperating with you. They will start providing you with all the things that you need. But 19.2 and 19.3 is, in any case, would be needed, because the kind of cooperation that you are expecting from the ex-management, more often than not, it will not be coming. As somebody very rightly pointed out in the first part of the session today. It won't be coming. I think it's a very safe presumption to make, that the ex-directors are not going to provide you with all the information that you're seeking. In fact, they will probably be very polite but very, very non-cooperative. Third stage. When you are in control. Now, this is the stage when you see company is a going concern. You have floated. You have already formed your opinion on avoidable transactions. There are potential RAs who are in touch with you. The COC meetings are happening in parallel, where you are getting all the financial calls, financial decisions ratified by the COC. Now, this is the time when, for your employees who are showing trust in you, some kind of carrot, some kind of incentives, you can provide them. Whereas those who have consistently been showing you non-cooperative behavior, you can send them on paid leave. That gives a very strong message. If you send them on paid leave, it sends a very, very strong message to other people also. You must take regular meetings. I think it is important for the RP to show that he's there. She's there. You don't have to micromanage, but you have to be there. Because many a times things would happen.
Rohit,
Blame would be given to you. Yes,
Rohit,
Ravi.
you're talking of paid leave or unpaid leave, because anyway, CD is under CIRP. Having a cash flow itself is a challenge.
See, you are not sacking a person. Okay, you can
Yeah, we are
sack a
not
person.
sacking. We
No,
can sack a
see,
person, but we are saying unpaid leave, as no cash flows are there.
look. Again, these are degrees of interventions that you can make. It starts off with calling them to your office, rebuking them. If that is not working, maybe in front of 5 people, telling them or giving them a message. If that is also not working, okay, then you send them on unpaid leave, or paid leave. Then if that is not working, unpaid leave. So these are steps. I'm just saying this is one of the ways of doing things. There could be many. You can actually sack a person also. That's not a problem. You can sack a person. If somebody is not cooperating, then you can sack a person also. You can take that decision to the COC and you say that these people are not following, but then you have to measure it. If sacking a person creates more trouble for you from the workers, from the workmen, then whether you would want to do that. So all those things are also very important. See, I faced a situation where the workmen, they went on strike. And they went on strike and they did hartal within the premises of the units. All the assets, all the key machinery of the units were very, very vulnerable at that time. Anything could have happened. So I had to take every decision with the sense that if anything goes wrong, the assets are going to get destroyed. So these are the kind of things, as I said, there is no right or wrong answer here. These are things which will have to be judged using your own wisdom. But there are some tools that you have to use. People are going to try to overpower you also. Overpower you in the sense that overwhelm you. So you need to be assertive in the meetings. When you are taking the formal meetings with tier 1, tier 2 kind of people, you need to be assertive. You need to be a little tough with the vertical heads, but a little easy with the second and third line managers. The demeanor has to be a little tough now. You have already eased into your role. Now it is the stage when you have to display full control. And the control should flow naturally from here on. and believe you me, most of these large companies, which are functional, which are running, and they get into CIRP, most of the times the RP's role or the CIRP period gets much extended beyond the 270-day period, which is stipulated. Because of something or the other, the CIRP gets extended. So it is important that you are in control all the time. No pilferages, nothing of that sort should happen. Nothing should happen where later on, either IPA or RBBI get reasons for taking actions against, or think that it is the unbecomingness of the RP that had led to a particular situation. So you need to be in control. If you're not in control, those situations will get created. The RAs will create tough situations for you, because the RAs who are going to be there, they are also getting consulted by the Big Four. So they know each and every part, that where the RP is going to be vulnerable, where he is weak, where he is not. So you need to be, showing control is important. So at the end of the day, if I have to really sum it up in one word, it is human resource. It is the people with whom you are interacting. And it is through people only that you are going to exercise your role as RP. Basically, what I'm talking about here is the fact that you are interacting with human beings. You are interacting with people. You have to display traits of a leader, of an entrepreneurial manager, I would say, in every aspect. And the most important thing when it comes to managing people is communication. And communication is not talking in English. Certainly not. Communication is great ability to listen and great ability to put across what your thoughts are in whatever language that you can do that.
And of course, reading between the lines.
Absolutely, sir. And giving messages, non-verbal messages. So I think you are going to be interacting with human beings. So it becomes very, very important that communication is very, very strong. Communication, there are many models of communication. I take a particular session for the fresh IPs. Recently, last week only, I took where half an hour I had spent on communication itself. So the 60-hour program for fresh IPs. So basically, you see, the most important part of communication and establishing your writ is that whatever you communicate, be consistent in that. You cannot be saying something and doing something exactly opposite. You can't be doing that. People will see through it. They are very smart. Most of the times, we tend to believe that we are the smartest and people that we are interacting with are not. But I'm sorry, that's not the case. They are very smart. Probably we are not. Be consistent in what you communicate, what you do. You have to show empathy. Empathy, anyone? What is the difference between empathy and sympathy? Anyone? Can anyone please tell me what is the difference between empathy and sympathy?
Empathy is understanding and sharing the feelings. Sympathy is very plain. It's sympathizing, so it's a pity.
Well, if I have to say define these two, you see, empathy is something when you put yourself in the other person's shoes. Say, for example, if somebody is undergoing a very troublesome situation in life, can you put yourself in that person's shoes and understand what are the feelings that he or she would be undergoing? If you can do that,
only by really talking to them and making them talk out and get into their hearts. It's only
correct.
It's a human.
Correct. So when you show empathy, you basically are displaying your ability to put yourself in the other person's shoes and then thinking what is going on in their mind. That is what empathy is. Sympathy is when somebody is, in a pitiful situation, then you are basically feeling bad about that guy. Then you're feeling bad about that person. Oh my God, what kind of terrible situation that person is getting into or has gotten into. That is sympathy. When you show some, okay, help him out or help her out monetarily or through some other means. That is sympathy. Empathy is your ability to understand what that person is going through. Believe you me, many a times, many people, they do not have that ability to empathize. They just cannot put themselves in that other person's shoes. They can't imagine. They can't think of it. And this is where I feel, many people would fail. So if you have that capability to put yourself in the other person's shoes and then think what is the thinking going on that person's mind, then you certainly have empathy in you. And if you have empathy in you, you will be able to manage human beings and human resources far better. Okay, some more stuff on leadership, motivation, team building. Again, these are things which I thought are important. They are not part of the code. No one tells you about this, but these are important things. These are softer aspects of being a manager, of being an IP in a company which is a going concern. As an RP, you are at best. When you are beginning, you are at best a legally imposed leader. Nothing more. So I would say you need to communicate more. You need to be present and be seen. Again, I'm repeating the same stuff, but it is important. Acknowledge the performers. Judiciously use carrot and stick. Within the constraints of being an insolvent company, you can still have some rewards and recognition also. You can do that. Be consistent in what you do and what you say. And if you are wrong, accept it. Rectify your stance. Never be overtly aggressive. As they say, you have an iron grip in a fur glove. Or if I put it differently, you need to be polite yet firm. Politeness you should never leave. But yes, if there is something that you have to communicate, be very firm in that. And again, the fundamental principle of human management. Reprimand in private, but recognize in public. Can anyone explain what I've just said, the last part? Reprimand in private, but recognize in public. So any recognition, any reward, or any pat on the back that you have to give to anybody, that needs, if it is done publicly, if it is done in front of other people, then that gives a much more boost to that person who's getting the pat on the back. But if you have to grill someone, if you have to really, reprimand somebody for something, then it is always advisable that you do that in private. Don't do that in front of others.
Rohit ji, Kanti here.
Yes, Kanti ji, tell me.
So while it is good for general public, and I agree with you what you are saying, but can we take it to COC members? Sometimes the COC members are very tough to, and sometimes you have to handle them delicately. So if you do not at that time become strict in the COC meeting, then the message doesn't get passed on to others. And sometimes you do it in your team meetings also, that you reprimand in public just to pass on the message to others.
No,
Do you
you
have
do
any?
that. Certainly, certainly. You see, again, I have been an RP in a company which was a going concern, where some of the COC members were private individuals also. They had invested in that company in their private capacity. And they had a huge grudge against the promoters. They thought that, the company has become insolvent, and it is the promoter who had a personal role in that. So they came with that feeling.
Most of the cases, we have got the collision of the financier and the CD, particularly the promoters, sir. Most of the cases of the fundings have happened of the major banks only with that, the relationship. So long that, there is a different team which is coming from the banks, particularly a different perspective, it is very difficult, sir. It is very difficult to handle them because you cannot trust your COC. And most of the time, whatever we discuss in the COC, even on a private, even without the presence of wherever the sensitive issues with the specific request of the CD promoters, it gets passed on to them, sir. It's very, very difficult on those cases.
I agree. So these are challenging things. These are practical aspects of being an IP. But I think by and large, I would suggest that in the COC, you need to identify who are the key COC members, and that of course you would be able to do that. Some strictness, of course, is possible, but too much of it also in the COC, you should also, it should not become an exercise in getting you lose the case.
You'll be targeted.
Correct. So at some level, you need to be discussing and at least having the relationship of trust with key COC members. So say, for example, if one particular financial institution or bank is having 35% vote share, this is the lead bank, and then the second lead is having a terrible opinion about the lead bank, and it believes that it is because of the lead bank that the company has become insolvent. So they are always fighting. Okay. So you need to balance the two out. I think again, all these human, all these behavioral interventions would come into play there also. So it is your managerial skills, your ability to handle conflict, manage conflict, that becomes the key. Again, going back to the presentation. Right. Okay. I was talking about managing personality conflicts, etc. Being in the driver's seat. So what to do and how to do? Again, a little bit of more of that. Communication. I think I've been emphasizing on this a lot. You open a discussion, then listen, and then do the final conclusion. Let the last words be profound and let the last word be yours. As far as negotiation skills are concerned, you need to be clear, consistent, yet tough. When it comes to managing personality conflicts, and this you will be doing a lot, you always take a principled stance, align the objectives of the conflicting person with the objectives of the company or the CD or the process, CIRP process itself. If you align them, then certainly there is something better which is going to come out of it. How to do that? Again, much of this I've been talking the whole 1 hour, last 1 hour is this only. You have to be firm yet polite while communicating. While negotiating, you have to conclude the discussions with a win-win approach. Let both the parties, whoever are participating in that negotiation, get out of that room feeling that they have got something better than what they had anticipated. And now that is a skill. Both the parties must walk off the negotiating table thinking that they have got a good deal. Show empathy with both the conflicting personalities, show respect, but clearly communicate the principled stance that you are taking. Coordinating with the COC. RP is appointed by the COC and his or fee is fixed by the COC. Does that mean RP becomes subservient to the COC? How to strike a delicate balance between RP's role and a possible COC's overbearing presence. Now, these are the skills that one has to display. RP is not subservient to the COC. RP is working along with the COC, taking the COC along with him towards a resolution of that case.
Again, sir, and this is very important if you can guide us and train us on this, because while on one hand, RP is the chairman of the COC meetings,
Right.
on the other hand, that agenda is driven by the COC and they at times overrule and dominate the. So what you are telling is very, very important. And if you can guide us on that.
See, I think most important is the COC to have trust in you as the RP. How do you develop that trust? How do you develop that sense in the COC that you are the best person in the job? At the end of the day, COC has the power to replace the RP at any point in time. Now they have got the power to replace the liquidator also, right? So it is imperative that the RP or the incumbent IP displays the confidence that the interests of the COC or the interests of the creditors are paramount for him as well. And I think if that gets done, the COC members would generally be supportive of the IP. If they see the IP to be working in the direction of things where the benefits of the creditors are being taken care of, the interests of the creditors are being taken care of. But at the same time, you have to understand that it's like you being a CEO where the shareholders are the COC members. So at the end of the day, you are working for their benefit, but you have to get all the decisions or things that you think are in the best interest of the CD to be endorsed by the COC members. It's an art, it's a skill. I can only say that these are important things, but I think this is over a period of time that one would learn. People who have worked in corporates, people who have worked in senior position in corporates and who are becoming RPs or IPs, they can understand this better compared to people who have worked in firms or who have run their own practices. Because running your own practice is basically you're a service provider. Whether that service is compliance service, whether that service is audit service, whether that service is legal service. So you are a service provider. So generally speaking, this is not the aspect where one gets really trained. But somebody who has worked in corporate, who has worked in a CFO position or a chief legal officer's position in a company, they would understand what I'm trying to say, and they'll probably be able to do this much easily.
Very truly said, sir. Your entrepreneurial skills should be there, and not just the audit picking and nagging, but you should have looked at the business perspective rather than the audit perspective. So long if you had that experience, even as an investment banker, even as anything that to do with the the different out of the box thinking, you will be able to do much better. And that's why I hope that this mentor-mentee concept will also help. Thankfully, that's been initiated by the IBBI. So I think it's important that you have to look at from the managerial perspective of managing. Most of the time, as you rightly said, so long we are professional and we are exercising our professional skills, COC automatically falls in line, sir. 2-3 COCs you need to run, and you need to, as you rightly said, you need to do some networking with them and to see to that their buy-ins are taken, and not just the COC, that you need to see to that you understand them much better. If they want your time and they come to your place, you need to understand them. And similarly to the management also, you should tell them if they've got any other angle, you should encourage them if they want to go for it only any day, you have got a chance, and you need to keep them patting that you look for whatever we need to do, will support you on that occasion. We need to tell them. It's a variety job, sir.
Correct. Absolutely. Very rightly put, Narasimhanji. Very, very rightly put. All right. So moving on. Again, when it comes to coordinating with the COC, you have to build a winning combination. What to do? Again, communicate. But here it is not just data, but you are also providing your analysis. So when you are presenting the financial data of the financial health of the company, or the inventory status of the company, do your analysis, do the past analysis, and then going forward, what is happening or what you envisage in the next 8 to 9 months or 7 months that the CIRP is going to run. So give your analysis as well. Prepare well for the COC meetings. I don't think it will be good if you even if you know everything, but it comes across that you are unprepared and you have a hassle to look and feel. So again, that is not going to give a very good image to the COC members. And believe you me, some of the times when the cases are big, I have seen people at the level of GM, CGM level also participating in the COC meetings. So so I think it is important that one is preparing well for the meetings. You have to also, as an RP, demonstrate some quick wins, like for example, opinions on your avoidable transactions, finding out, I'll tell you, I'll not name the case, but in my case, what was happening was in one of my cases, large cases, the TRA account was already in place. Anyone knows what is TRA account? Anyone can define what is a TRA account? So basically, when a company becomes NPA, so it gets declared as an NPA by the consortium. So what the consortium tells the corporate debtor is that all the transactions are going to happen only through one bank account. Okay, and they as the payments come in that bank account from the different wherever the material is getting sold and the revenue is coming, so they keep taking some money out of that TRA account. So there is only one account which is functional, and the CD has to make a declaration that there is no other account which is functional. In any case, when the NPA gets declared, it is an RBI mandate that any new account opening gets restricted. So what I found in one of my cases is that I could, through my own network of people, I could clearly demonstrate that to the COC that there were bank account in private sector banks that were being operated without the knowledge of the creditors.
Sir, forget about private sector banks, sir. We have come across situation. It's not a small account. It's a very large account, and as big as that, the major banks in India, have
Yes.
operated, continue to operate the erstwhile account before moving into the TRA, and they have received monies and they have tried to do the appropriation into their accounts. The best part is the consortium bank, the lead bank has also done, the other banks also done. So nobody want to take it to the legal remedy also.
Yes, yes. So these are things.
Particularly two things they tell, sir. They don't want to take it to the CBI.
Right. So
they will not take, because you cannot take it to CBI.
Correct. You are right. So what I'm trying to point out over here is that, to the COC members, you have to demonstrate some quick wins. Whether it is improving some operational efficiency, if there is a particular rate in, rate of loss, operational loss or operational profit, whatever is there. So if it is operationally loss-making company, then you have to reduce that loss in your tenure, or quickly you have to do that. And if it is a operationally profit-making company, then you have to ensure that the profit gets increased. So, say for example, in one of my cases, the dollar rate suddenly changed, and we were only as the CD, we were just doing job work for the vendor, for the actual exporter, but that exporter was also a sister concern of the CD. So basically, what they were doing was, there is a technical term which is called phoenixing. So they were indulging in phoenixing, and this has become a ground for me to file Section 66 application against the promoters. So when the dollar rate changed and dollar became more expensive, I told that exporter that, look, you are going to make a lot of money. You have already, although he had done a deal or a agreement was already done with the CD for paying a particular amount for the job work, but we got it increased by 15% because the dollar exchange rate also increased. And when I showed that to the COC was really happy that, on the basis of the work done by the RP, the CD is operationally earning more compared to what it was earlier. So I think these are the kind of small things that you need to do. Never hide anything, any intentionally or unintentionally, any financial information or financial decision. In fact, now every financial decision has to be by law ratified by the COC. Earlier, it was not the case. Now the regulations have undergone changes. So now it has become absolutely important for every financial decision to be ratified by the COC in the COC meetings. All right. Always give the COC some valid reasons. Whatever views that you're giving, that needs to be backed by data. That needs to be backed by information and analysis. You need to evoke trust with your knowledge and capability. Lead the COC meetings. Never let one member or the two members hijack the meeting. That makes your position very vulnerable, very vulnerable. So you need to always lead the COC meeting. Say no firmly yet politely on any unnecessary point or opinion that may be detrimental to the interests of all stakeholders, and communicate that properly. Communicate that lucidly so that it gets its due impact. All right, so I have a case study here, a small case study. Do we take this case study up, or you want to do it offline after the meeting is done? Because I am pretty much
going along with you, sir. With your knowledge, you should be able to do much better.
Okay, so let's take a 5-minute break. I've been speaking continuously for now more than an hour. Let's take a 5-minute break. Let's reassemble here again at 40 minutes past.
In the meantime, I will continue.
Yeah. So why don't you read this? I think 1 second.
Put it on full screen.
Yeah. 1 second. So one of you can read it. I think there's already a volunteer. Please read it out loudly as I take a small break.
Case study, Mr. N. Vedam Yanam gets appointed as IRP RP of Mrs. Moonlight Chemicals Limited. Mrs. Moonlight Chemicals Limited CD is a stock exchange listed company that has defaulted on the payment of its debt obligations. There are 5 lenders who are part of a consortium led by National Bank NB having 37% of vote share. Our capital bank CB with 10% of the vote share files for CIRP under section 7 of the IBC and proposes Mr. N. Vedam Yanam NVG as the proposed IRP. The matter gets admitted by the Honorable NCLT and NVG gets appointed as the IRP. Premnath Agarwal is the CMD of the CD and CA Raghunathan is the CFO of the CS. Shashi Shetty is the CS under Legal Officer CSLO of the CD. And Mr. Madan Lal is the Chief Production Officer CPO of the CD who looks after the plant. The CMD confides with the CFO for all the financial matters and trusts the CFO. The CFO has a difficult relationship with the CPO. CPO is basically the production officer, chief production officer, and has fed the CMD with negativity about the CPO. Immediately after the pronouncement of the CIRP order, NVG's legal team sends well-drafted legal notices to CMD and key managerial personnel of the CD. NVG's custody team goes to the site of the plant on the same day as the notice to CMD and tries to forcibly take the control of the security of the premises. It leads to altercation and the workers working in the unit come to know about it.
Next.
NVG schedules his visit to the corporate head office of the CD after 7 days from his appointment, and NVG's legal team informs the CMD and other key managerial personnel of his visit. NVG visits the head office along with his advocate. The CSLO ushers them into the conference hall where the Chair 1 and Chair 2 management of the CD are sitting. NVG takes the biggest chair in front of which a metal tent cord with CMD being embossed is kept. He asks his lawyer to take the seat next to him. The CSLO tells NVG that the CMD would be joining in next 15 minutes as there is an emergency in the house. The CSLO then formally introduces NVG by telling that Honorable NCLT has appointed him for the resolution of the CD. NVG then asks his lawyer to give a presentation wherein the provisions of IBC that empowers NVG are displayed. Then there is presentation about the penal provisions for those who do not cooperate with him. Just as NVG's lawyer is giving the presentation, the CMD enters the conference hall. All the members of the team rise from their chairs. The CMD greets NVG and looks for a seat. The CFO, who is sitting on the other side of the NVG, gets up and offers the CMD a seat. The meeting ends with NVG telling the key managerial personnel that he can be contacted over his email. It's week 2 after NVG's appointment, and his office receives a communication from the stock exchange that the non-payment of dues may lead to permanent delisting of the shares. NVG sends a scathing email to the CSLO with the CC to the team of CSLO and the CMD about gross dereliction of duty that may result in permanent delisting of the CD's shares. Every time there's problem that's brought to the notice of NVG, he either does not respond or at times talks about the law and its provisions. NVG visits the CD's office towards the end of third week again and asks the CMD the CFO and the second chair management in the finance team to come and meet him in the conference room. There he asked that why, despite his emails, certain details about financial statements has not been provided to him. The CFO tells RVG that two critical members of the staff have gone on leave, hence the data remains incomplete. A silent non-cooperation that is palpable amongst the team members. It's week 4 now. The NVG has scheduled the first COC meeting and is not sure that in absence of the critical financial data, how we can handle the queries of financial creditors is clearly in stress.
Right. So, very interesting case study, right?
Yes, sir. But why our RP has not acted according to the fundamental principles? He should have been. If I'm the IRP, I would have been sitting in that office only. I would not have moved unless it's a COVID time.
So
Even
let's
in that case, I would have ensured
yeah.
that I come and sit in this office.
Yeah. So let's try and understand from the participants here. So we have gone through this small case study. So can you please list down what are the things that were done wrong by Mr. N. Vedam Gyanam? The IRP. What were the wrong things? What he should not have done?
So
With the
starting,
paucity
I
of
would
time,
say,
can we shoot out straight away? So, or would you like it to be?
No. So I think one by one. So maybe
I will be the last.
So I think we should have the other participants also. So I would request the other members.
So I would say first thing is that he took the chair, which he could have easily kept for the CMD just to show him the deference and get his support in the future.
Very good point.
That is one thing that I usually do, is to give respect to the promoters. In one case, I was sitting in his chair in his office, and when he came, I vacated it. So I think that's something that. Secondly, I would not have asked my lawyer to make the presentation and speak about the penal provisions. I'm looking for support of the team, and I would rather tell them that, look, I have been appointed, and I would talk more about the positive side of it, that please, I need your trust in running the company, and your services are going to be intact during this period of CIRP. And we are looking for revival and not closure, which is in your good interest. And therefore you support me and I support you, kind of thing, rather than talking of the penal provisions.
Very, very true. Very true. Anybody else? Anybody else about what wrong did the IRP do? What were the wrong things that he did?
NVG custody team goes on the plant on the same day. It should be gone on the someday after some day of the notice. Or
exactly.
tries to take forcibly control.
He went to the office of the CD after 7 days, and knowing fully well that it is it is a going concern. Still, it took him 7 days to go to the CD's office. Yeah. I think that is.
I would add one more point, sir, that you should have taken all key positions. He should have kept one staff from his side. Even if he doesn't have, he should have borrowed the team, and he should have put on all the key positions. He should have kept people. By then, you would have understood that most of them all critical information. He should have taken the backup, and he should not have allowed that that data to be erased or moved away from the premises. He has not acted as a prudent IRP, sir.
Absolutely. What do you think of should he have first, the moment he would have come to know about the admission of the case, was it not imperative upon him to have gotten the phone number of the CMD?
Not only that phone number, sir, immediately he should have acted to take charge of the entire organization, including taking control of the banking and everything. He should have intimated to the bankers immediately on the very same day or the next day.
Correct. So
even
let's
before
assume
the public announcement, you should have given them the notices to all the key banks and everybody to freeze the account and ensure that, everything. You should not have stopped. We have done in the cases of going concern, and we have got the blessings of the COC also. All those transactions should have got routed through, all the payments should have been routed through himself personally from that minute, sir.
Correct. So as there is nothing which is written on that aspect, so let us assume that that was done. So let us only focus on the aspects or the facts which have been stated in this small case study. What did it do wrong? I think the first thing, if I have to really, of course, all the things that you have said are very true. What Mr. Rustagi said was also very true. Mr. Jain also pointed out to a very right thing. But whenever you give your form 2 in such a case,
I believe that he should have met separately with the top management and rest of the staff.
That's a good point. That's a good point. See, 2 or 3 important things here. If it's a going concern and that it's a going concern when you are giving the form 2, obviously, it is imperative that being the proposed IRP, you should track that case in the NCLT also. So you would, when you are tracking that case in the NCLT, even though you are not, or it is not your legal team, which is, which is trying to get the Section 7 application admitted, but you are the one who has given his form 2. So therefore, it is important to keep a track. Therefore, it is important to have all the background information ready with you. And one of the most important background information that is required is the contact information of the key personnel in the CD. With key personnel, I mean the board of directors, the key movers and shakers in the CD. You must have their contact information, because if it is a running unit or a running company, it's not that they would have fled the country. It's not that. They would still be very much here in the country, and the very fact that the Section 7 application has got admitted means that even they are, in a helpless situation where even they have not been able to come out of the stressful situation that the company has gotten into. So giving them a benefit of doubt, not treating them as criminals right away, trying to get in touch with them using, whatever means of communication, and communicating to them that, look, this company, your company might be getting into, or the CIRP might be starting. I think it is not a bad idea at all.
Sir, I would have, if I were in his place, I would have communicated all through the email communications, and I would have pasted it as required by the IP.
Exactly. So that is something
on the walls. I would have consolidated the meeting time with the understanding of the business and the operation, the what support they would be requiring, as that he is replacing the board of directors de facto.
Correct. So that is exactly what you are doing, that you need to do. Once the order comes, then of course everything which is related to pasting of the notice, etc., putting your people in place, immediately appointing those people to key positions and letting the hierarchy know about it is important. Showing deference to the CMD is also important, because you cannot just be so rude and arrogant.
So we don't recommend, sir, as a matter of principle, when we are appointed as an IRP, that we do not occupy the CMD seat, and we rather observe whether he is occupying first of all, right. And if easy also looking for, like, the respecting the court order. First, we are missing one important informal communication that you would have received, message that you would have received, whether he is trying to do de facto control of the business, even after knowing that well that he is not the de facto controller.
Correct. Right. This is absolutely correct, Srinivasanji. Okay, there's another interesting fact over here. So we now know what all wrong things that he did, right? There's another interesting fact over here which talks about, or which kind of takes us in the realm of COC. It talks about 2 financial institutions, National Bank and Capital Bank. Who is filing the Section 7 application?
10% CB.
Correct. So who is having the veto power? National Bank. Correct. So
if NB, I have to replace it with the State Bank of India without any harm meant. The first thing would have happened is that the replacement would have been the first move on the COC.
Well, I will not comment on that. It actually happened with me in one of my cases where the Section 7 filing bank was having a 9% stake, and the largest stake was with a bank having 17%. It was a 21-member COC with probably all the public sector banks over there. So, I drew this particular case study partly from there also. But fortunately, all 100% of the banks, they voted for me when they were, confirming me as the RP. All 100% they voted. So I'm thankful. So you are right. Normally, SBI, they try to do that. In my case,
Sir,
SBI was having a share, but it was not significant.
SBI head office has appointed, the local office would like to get the replacement done. So that is a level of the great integrity they have got with we have got with the great banks in India. So we should be prepared and we should demonstrate. In this case, it is a cakewalk for NB to replace him without even second thought that in the first COC
Right.
it could be replaced with the comfort.
Right. So basically, with this case study, I wanted to emphasize on the fact that these are the many, personality or behavioral part of our role as RP that we probably miss out on. And particularly, these are very important when it is a going concern. Because you as RP, IRP, RP, you have to display the traits which the code doesn't define. The regulations doesn't talk about. The regulations and code are very clear about, the framework. And you have to work within that framework. But that framework is very broad. Within that broad framework, how do you operate? So I think if you have one or two principles that you keep in mind always, firstly and foremost, I think you are operating as the head of the ICU. The patient is the CD and you have to rescue that patient, you have to revive that patient. If that is the kind of sense that you get into, and step into the roles of the RP, I think most of your decisions are going to be driven from a very correct perspective. Most of your behaviors are going to be emanating from a very correct perspective. So I thought, to share all these thoughts with you, all of you, when I was preparing these slides. Of course, the compliance part, my partner has handled, and he's handled it quite well. So I think with this, I have come to the conclusion of my presentation. If you have any more questions, I would be very happy to share that.
Sir, in this very important point you raised, and we have not addressed it, if you do not mind. You have talked about delisting situation.
Right.
What you should have taken control of, because I'm not a company secretary. Obviously, I will have my team member to handle it. What you should have done on that circumstances, sir?
You see, I think the point that I was wanting to make, it is important that the delisting should have been avoided at all cost, right? But at the same time, the point that I was trying to make is the kind of communication that IRP was making with the chief secretarial and law officer. He thought that the communication that he was doing was very, very harsh, that it is dereliction of your duty, etc., etc. Even if a notice has come. See, it is important to note that the notice has come to the IRP.
Sir, but it's immaturity shown by the IRP. So, I agree with you, sir.
No, so see, I think the subtle point that I was trying to make was that the notice came to the email of the IRP.
Sir, may I
somebody would have told, somebody within that company would have told that now the company is being run by the IRP legally. So everything you please, if you have to communicate, directly communicate with IRP. So that means he did not understood that this was getting redirected from within the CD itself. Somebody in the team which was handling the compliances would have told the stock exchange that please communicate now with this guy, put him under pressure. You should have realized that also.
In any case, can we not invoke section 14, sir?
Regarding?
Moratorium.
No, those of course you can. Look, you can always tell the stock exchange that all the pending payments which are due from the CD, please file your claim with me. And whatever payment is due now, after the invocation of or the initiation of CIRP, that of course you will have to pay.
Will be part of CIRP cost.
Correct. That will be part of CIRP cost. Absolutely correct. So those communications, see what I'm trying to tell you over here is that these are the subtle things that you need to catch.
No, you should have taken as a team member. You
Correct.
should have said, it's not your problem, it is my problem. See, that's what we do in a corporate environment, right? You as you rightly said, when there is a problem, we say it's my problem. And when there is good, we pat them saying that, it's because of you, we achieved that. So he has comfortably is not coming from the background of the business. So he doesn't deserve the position as an RP.
Well, I will not go to that extent. All I would say is,
I mean, even if I were there, I should take that as a lesson that I should not commit these mistakes.
Well, I think more of it is to do with the kind of learnings that we get out of this. I think these situations are common. And that's the reason why I keep telling, whenever I am taking any session, is that please remove your hats as auditors, please remove your hats as compliance officers, please remove your hats as advocates, and put your, put all the hats together, and on top of that, put the hat of a manager or entrepreneur. And then you will be able to do a good job when it comes to managing CIRP of a going concern. Otherwise, it will be very difficult.
Can I ask a question, please?
Yes, Khandelwalji.
Can you spare a minute for how you would prefer to take the custody of the assets of the debtor immediately on getting an assignment? Because I think that is a very, very important part, and that needs to be done immediately to avoid leakage. So how would you go about that? A minute on that only. Yeah.
Sure. So I think it's the most important part of the role of the RP to ensure that the value of the CD, it gets protected, rather it gets enhanced during his tenure. Now, I think there are certain steps that one needs to take, which are before the case gets, admitted under Section 7 or Section 9 or Section 10. So if you are somebody who has already given your Form 2, then the admission of a matter will not come as a surprise to you. In fact, as a diligent IP, I would expect the IP to be following up regularly on the proceedings in the NCLT whenever he or she has given a Form 2. So firstly, when it doesn't come as a surprise to you, you would have also done some kind of background check in terms of what are the kind of assets which are there in the company. If it is a Section 7 application, then obviously the bank which is filing, or the financial institution which is filing the Section 7 application, you can certainly come to know from them that what are the kind of assets, what are the kind of units, is there any functional unit, etc. All those kind of informations you can have with you. So the moment the order gets delivered, so that makes it incumbent upon you to take charge. So when you have to take custody, say for example, if there is a company which has got one unit which has been in a shutdown condition for the last 1 year, there's another unit which has been shut down for 3 years. For that second unit, the lead bank has already taken SARFAESI action. But for the first unit, there was no SARFAESI action that was taken. The second unit, again, despite SARFAESI action and despite the bank itself having its own guards, security guards on the asset, it has not been able to sell. So what would you do as an IRP the moment the company gets into CIRP? So I think you need to have your team. Your team must have somebody who are interested with taking custody and control. In that team, normally when I talk about my own IPE, so we have people from ex-servicemen background. So they are the ones who are there, who are responsible for taking the custody and control of the assets of the company. So they go, with whatever information that we have, whether through balance sheet, whether through previous valuation reports.
Sir,
So there is a list of assets that we have.
Sir. Whenever I give consent, have given consent to the going concerns. What I do now, whenever I give the consent, I go pay 100 rupees, just 100 rupees, the MCA website, download all the forms which are filed, which is the first thing which I do, so that I don't need to depend on neither the bank, because bank has got the procedure of giving the information. They don't give you immediately, and they'll say when it is admitted, we'll give. So I don't go to the banks or the financial institutions who are recommending me. I go to the MCA website, download 90% of whatever you have said. I'm able to control it even prior to that, that have an understanding even prior to that, the order coming in. So I'm not in surprise by the time the order comes. Exactly. I know what to handle from the published financials and published audit reports and everything. Most of the relevant informations are already covered by us. And also going through the internet, I know that, what are all the major actions taken. And these are all already done. I don't need to bother for the SARFAESI, like what you said, because the SARFAESI action will be put on hold, and it will be your custody the moment you step in as the IR.
No, Srinivasanji, what you said is correct. In terms of digging out the information from MCA website, from Zwaba Corp, or from any other Toffler or any other website, it is important that's what I said. There are certain steps that you need to take prior to admission. So these are the steps that you have to take, digging out information from the MCA site and all. What I meant by saying that if there is a unit which is under SARFAESI, and if there is a unit which is not under SARFAESI, then the kind of control that you are taking from. So for unit number 1, you are taking control from the CD directly. Whereas from unit number 2, you are taking control from the FC, right? So these are two different things. Whereas because unit number 2 is under the control of the financial creditor who has taken the SARFAESI action. So the kind of documentation that you have to prepare, the kind of things that you have to prepare for taking over the handing over or the possession of those units. So the paperwork that you have to do is different for both the cases, right? So the person who is going to take the custody, he has to go prepared with a tentative list of assets which are there or there. Generally speaking, you also have to make somebody who knows about valuation. You can, in your team, you may have somebody who understands plant and machinery valuation, or if he's a plant and machinery valuer, if you can ask him to accompany your team when they are going to take the custody. So a proper inventory has to be made of the assets. There is a panchanama that has to be done with 5 different people signing off on the panchanama. When you do all that, after that, if it is, when you do that, it has to be countersigned by the bank if it is a unit under the custody of the bank, and it has to be countersigned by the CD, if there is an existing manager in the CD, they have to sign off, and then you have to sign off that this is the list. There is videography that has to be done properly. You have to place your security guards over there, right? So this is how you are going to take the custody of the assets of the company. It's very important to do all that correctly. Particularly now, they have also put on the shoulders of the IP the responsibility of taking in control all the documents also. Now this becomes very challenging because even the documents
at
of
what stage would you like
CD.
to do this? The custody of the assets. Within how many days would you like to do it? 1 day, 2 days, 7 days?
See, I think ideally, it has to be done as early as possible. I don't think there is any time limit which is prescribed, as early as possible. But you must give, if you must give some kind of formal notice to the ex-management or the bank, if it is holding, some kind of formal notice you must give, so that using that you can show them that I have given you a formal notice. Now please hand over the custody of the assets to me.
And how do you prevent leakage in the interim? Let us say stocks being moved out or something, or
See,
the other books being manipulated.
See, the day you take over, is the day when you are signing off. And you are preparing a list of inventory of things and items which are there. And then you are countersigning it off with the CD. So the day that you are taking the custody, that gets recorded. So anything which is prior to that, you can always say that pilferage has happened before that.
Okay, so between the CIRP commencement date and the date of taking custody, there could be pilferage, which is unavoidable.
Which is, I mean, look, you are not Lord Vishnu. You are not Lord Vishnu as an IP. If the order comes today, it cannot be expected that you are going to have everything under your control the next second, right? The order gets delivered at the NCLT, it gets uploaded after 2 days. What happens in that interim period?
Essentially, my point, because the management also knows that the order has come out.
Therefore, one has to be practical. Even if there is any pilferage which happens between these 2 dates, you can always say that I have taken custody on this date. So the date and time, the videography and all would become the evidence of the things that you are taking over.
Okay, thanks a lot. I just wanted to hear your opinion on this. Thanks a lot. Yeah.
I hope it has added some value.
No, definitely, because you see, there'll be different ways of dealing with it by different people.
There are different ways.
Yeah. Thank you.
Right. So, any other question or any other thought, and then we can move ahead, or kind of conclude.
If I were, I would be happy that something pilferage or anything happens in the ensuing time. So what I will do is immediately I would not like this IRP. I would have planted people adequately into each site. Would have asked that the registers and other things to be taken, and within a week's time or 10 days time, I would have mobilized adequate resources to see that all the informations are gathered which are critical. And if something are missing, that's going to help me in strengthening those places by replacing the staff. That's where my skill sets are going to be put onto the use. Thanks for the session, sir. Lively session.
Thank you. Thank you so very much to all of you. And I think with that note, I would hand over, back to ICSI IPA. I think they are doing a great job in conducting these sessions on a very regular notice. I think all the IPAs are now doing a good job. they're all probably their parent institutions are not doing as much work as they are doing. So thank you so very much. Handing it back over to you, Trishla. Trishla, you are there?
Yes, sir. Thank you so much, sir. On the behalf of the ICSI and the entire team and participants, I would like to thank you for this practical and very informative session today. And I would also like to thank Bansal sir for the same. And thank you so much, sir, for cooperating. And we hope to have other sessions in future.
Sure. Look forward to that. Thank you so much. Thank you
Thank
so
you
much,
all.
all the participants. Thank you for being very,
Thank
very,
you, sir. Have a
very,
good
very
day.
cooperative with me. Thank you. All right. Okay.